Okay, Corey, we're ready to go live. Madam Chair, we are now live.
Thank you. Good morning, everyone. State Board of Education meeting will come back to order. Ms. Maramba, would you please call the roll?
Board Member Durham.
Here.
Board Member Escarcega.
Here.
Board Member Esser.
Here.
Board Member McClellan.
Here.
Board Member Rankin.
Here.
Board Member Shuffle.
Here.
Board Member Schroeder.
Here. Thank you. Chair will now have a presentation from CSI regarding the Keogat Community Academy. Commissioner?
Thank you, Madam Chair. Yes, welcome to our presenters here today. And so I'm going to turn this over to Joe Peters, who is wearing a slightly different hat. He's here on behalf of the Charter School Institute. So, Mr. Peters.
Thank you, Commissioner. And before I share my screen and put up the slides, I was going to do a couple of quick housekeeping notes, one of which is on that topic of which hat I'm wearing today. So I'll start there. As 5 of you are already aware, and I'm not sure if we brought this up yet with Dr. Esser or Dr. Escarcega, but we wear sometimes more than one hat in the AG's office. We represent all of the education agencies within Colorado state government, and occasionally that leads to some sort of a conflict of interest. And slightly more often, it means sometimes we're standing in front of you in a capacity other than being your attorney. Now, today, I am standing in front of you as CSI's attorney. I'm primarily assigned to represent them, or at least of the attorneys on Julie's team, I'm the one who handles CSI. Julie Tollison and I have talked it over. We don't believe there's any sort of a conflict of interest that would require us to look at conflicts counsel or anything of the sort. However, just to keep the lines of communication clear, when I'm speaking today, I will be speaking with CSI, with that CSI hat on. If you have legal questions that you feel you need to ask legal counsel for assistance with, Julie is present and available. She's planning to go over this with you next month when we submit the waiver requests for your approval. But on the fly, I'm sure she'll enjoy shooting from the hip a little bit. She always does. So the other housekeeping note I was going to cover real fast is that I submitted the slides and the board memo to you a few days late. I know they weren't in your board packets. It went out last week. That's entirely my fault, and I want to apologize for that. I was out on vacation and just didn't get it done first. All right, and with that, I'm going to go ahead and share my screen. Hopefully I can do this well. All right, so are you looking at my slides now?
Yes, we are, Joe.
Thank you very much. As you know from the board memo, we have a charter school applicant named Keogat Community Academy. They're a unique school and a very exciting and innovative project. It's a little more legally complex than a normal charter school applicant, and so we asked for this opportunity to come speak to you today and walk you through some of the unusual things you're going to see. And then next month, we'll submit the actual waiver requests for your approval. And thank you for giving us this opportunity today. Here's the way we're going to do this. Here in just a second, I'm going to pitch it over to Jill Anschutz and Dr. Terry Croy-Lewis and give you a quick introduction to the Colorado Charter School Institute. And then we're going to pitch it over to, I hope, Tina King Washington from the Ute Mountain Ute Tribe. If she hasn't had a chance to join us by then, Dr. Fulton, Richard Fulton from Fort Lewis College will pinch hit, I hope. They'll walk you through the application that KCA has submitted. And then it's going to come back to me. The tribe's attorney, Peter Ortego, and I will then walk you through some of these waiver requests that you don't normally see. And so with that, I'm going to hand it over to Jill and Terry. And Terry, if you want to just let me know when to advance the slides, I will do so.
Wonderful. Thanks, Joe. Really appreciate it. Thanks to everyone. Thanks, Madam Chair and the rest of the State Board. Appreciate taking the time to learn more about this exciting opportunity. And we wanted to present this to you so you as an informational session so you can learn about this school that will be starting in August and kind of about CSI and the processes we've gone through. So we'll try to keep the information about CSI pretty short so we can really focus on the school and some unique waivers that will be presented to the State Board next month. So starting with CSI, the Charter School Institute, and Joe, you can turn to the next slide. Thank you. Many of you are familiar with CSI. There are 2 new board members, so I wanted to make sure everyone was up to speed on who we are. We are the only statewide authorizer in Colorado. Our mission is to foster high quality charter public school choices, particularly closing the achievement gap. And so where are our schools and who are they serving? We have 42 schools this year. In fact, enrollment is up in our schools across the state. We have over 20,000 students, and you see them in all different places, obviously. We have schools in Durango and Fort Collins, in Steamboat Springs, in Colorado Springs, Fruita, Salida, so truly all over the state. We have 16 different unique school models. Again, our students mirror the students that you see in the geographic districts. So most of our student populations reflect the state averages. And so we really focus hard on ensuring that our schools are serving all students and serving them well. We have particularly been focused on serving SPED students that qualify for special education, and we've seen an uptick in that number over the years. And our outcomes are strong as well. Moving to the next slide, thanks, Joe. I'm going to pass it to Jill Anschutz, who is our board chair, to talk about our board. Thanks, Jill.
Good morning, everyone. I'm Jill Anschutz, and Governor Polis appointed me to the CSI board in 2019, and I became the chair in 2020. Really honored to have a chance to serve Colorado's families in this position. The Colorado Charter School Institute is governed by an appointed board of directors. The governor appoints 7 members, and those are confirmed by the Senate, and the Commissioner of Education appoints 2 members. Each appointee term is 3 years, and that can be renewed, so members can serve up to 6 years. By statute, our board is required to be mission-driven and politically balanced, which really provides steady leadership and stability for our schools. And I think it's important to note that our board brings a pretty diverse range of professional and public service experiences that add to our strength, including a board member who has a child enrolled in a CSI school. And we also have members that represent Southern Colorado and the Western Slope.
Thanks, Jill. So a little bit of information about authorizers in Colorado and the uniqueness of Colorado authorizing landscape. So the majority of authorizing takes place from school districts, and in Colorado we have something called exclusive chartering authority. And most school districts have exclusive chartering authority. And what that means is that an applicant must first go to the school district to either apply for a new school, or if it's currently being served by the district, if they wanted to transfer, they would have to get permission. If the district has exclusive chartering authority, they'd have to get permission to do so. So CSI can only authorize schools that are in districts that do not have ECA, or if the district has released them to apply to CSI. So there are 178 school districts in the state, as you well know. 172 have exclusive chartering authority. And if you've been on the board, you know in the last couple of years, you've had a couple districts come to you again to ask for ECA back if they had not had it. And so it's something that most school districts have. In this case, this school is located in the Montezuma-Cortez school district. And so we work directly with Montezuma-Cortez to talk about a release and why it would be a partnership that we could develop with the district and the school, and that's what we did. So in most of our cases for our schools, of those 42 schools, they're located in districts that have ECA. We can go to the next slide. I just want to really quickly talk about the application process. So when a school is released to CSI, or if they're in a district that doesn't have ECA and can apply directly to us, there is a review process. We have a new school application process that takes place in the fall and in the spring. So we have 2 cycles a year. This is a fall cycle. The school submitted their application in August and then went through the review process. As you can see, it's a very rigorous process. Action did take place by the CSI board in October with an approval, and then we went into contract negotiations. From the beginning in this school, we knew that there'd be much uniqueness about the contract provisions and waivers. This will be the first school in Colorado located on a reservation. It's the first charter school that will be located on a reservation. So we knew that there'd be quite a bit of learning throughout the process for us as an authorizer, for our board, for our staff, for the school to work with us to understand what we do and the intersection between state law, tribal law, and federal law, which Joe and Peter will be talking about later. So just a little bit about CSI, and I'm going to pass it on to the school. And I'm not sure if Tina is on. She's the education director for the Mountain U. I'm not sure if she's on right now.
Yes, I'm on.
Great, Tina, welcome. Good morning, and I'm going to pass it on to you.
Good morning. Wonderful. All right, good morning, everyone. This is an exciting meeting. Every meeting is exciting that's going to lead us to our Quiagat Community Academy. We started working, gosh, I think it was 2-3 years ago with this idea, and we are hopeful that this will help our students have a new and different way of learning. We are going to use the Montessori type, and we're also going to add in our own culture and language into this process. We just got a board yesterday. I'm one of the board members, along with 5 others. And our goal is to help our kids to learn in a different way and to be here on their own reservation and learn as groups rather than direct instruction, which is more lecture. That's our goal. Our students are doing okay in the RE1 school system. I can't say everything's bad because there are a lot of good, and there are some students who are going to want to stay in Montezuma Cortez, and that's fine. We'll continue to work with them. But our school will offer hands-on. It will be here. We are going to be using 2 of our own teachers right now for the language, and we are hoping that our students will learn and grow and become leaders, not only of our tribe, but of the country, and do many, many different things. And we are going to address some of the language needs that we have, because we do have them. And I don't think it's been addressed, and we want to address that in a different way and help them to learn, and to learn to use their own language as well as the English language and other languages that are important. So the Quiagat School is going to start with K in 1st grade. We are going to start with those grades here in the present building that I'm in, the K-12, and then every year we will add a grade until we reach full capacity K through 12. So those are our goals. We are hoping to have our parents as an intricate part of our school. A very open door policy will be part of our academy. And we are going to be working very closely with our students and our parents and families. What else did I need to address? I'm sorry.
Tina, if you could address quickly the partnerships and supports that you have lined up to help you launch this charter school.
Yes. Yes, we have many, many supports for this charter school. Not only our own tribal departments, who are very, very willing to help us and are already helping us with some of the things that we're going to be doing, like summer programs, after school programs. We have partnered with Fort Lewis College, and they are already working with us with tutoring, and will be working with us in not only providing other school sources from their school to us for tutoring and for programs in the summer. But we also have them helping us to get our teachers on board, or people to be teachers on board. So we will be having some of our teachers who are not certified will be going through a program at Fort Lewis to become certified teachers for our school. So we have 3 people lined up for that program. And in addition to that, we have the Pinion Project in Cortez, who has also been very interested in what we're doing here and will be willing to help and bring down different leadership conferences and help as far as parenting classes. They do those kind of things. Let's see, who else do we have? Just our own. Oh, and the school district, we are going to use the BOCES School District special education programs. We've worked with them for years. They have been very, very interested and willing to work with us when it comes to a Native student who is in a special ed program. And we have come up with some innovative ideas for some of those kids and are helping them be successful right now. So we're hoping to use them, and they're very, very helpful when it comes to working with unusual circumstances with students. And one of those ladies who work there is going to be one of our board members. So we're very pleased about that. And as we go through this process, we are hoping to have a good relationship with RE1, and they are very willing to assist in the transition of getting kids into our school. Well, not into our school, but once they're in the school, we are working with them so we don't have the bouncing effect of some kids saying, okay, I'm tired of this school today because you made me mad, I'm going to jump to this school. We are going to work on a memorandum with the RE1 so that we don't do that, and the kids do have a stable place and they stay and they learn, and not the bounce back effect, which is what we call it. Other questions?
I think we should probably move along, if that's all right, Tina, because we're starting to.
Absolutely. If you have other issues, I'm here. I'm willing to answer any questions. But we are very pleased with the progress we're making, and we're getting our building ready to go. And I think by August, we'll be ready to open our doors. Thank you.
Thank you, Tina. All right, so we're going to move on to the portion, the boring portion. We've just done all the fun stuff. Now it'll be Peter Ortega, who's the tribe's attorney, and me walking you through sort of the real meat of the information we want to throw at you today, which is some unusual waiver requests. And so this begins just by understanding the unique legal status of Native American or American Indian tribes under the U.S. Constitution. So tribes are not states. The right way to think about this is probably mostly analogous to a foreign country or a separate sovereign of some sort. And so as a result, even though the Ute Mountain Tribe is located partially in Colorado and partially in a couple other states, even though a large portion is within our physical borders as the state of Colorado, they are not subject to our laws or our government. They're subject to some, perhaps even most, but not entirely all federal laws, but they're not subject to Colorado law. That said, the tribe will often agree to follow and honor Colorado law in exchange for participating in a program as state-funded or state-operated and federally funded program. The way to think about that is probably most analogous to our relationship at the Colorado level with the federal government. So if you think about ESSA, or the entire ESEA that we've been working under for the last 50 years, the U.S. Congress doesn't have the authority to regulate our schools or our accountability system, but if they offer us money, they are free to attach conditions to that money under the spending clause of the U.S. Constitution. And so, we take the title money and then we agree to do the federal accountability system that we all know and love under ESSA. The tribe does that as well. The tribe will take federal funds and accept the conditions that are attached to those. And then they can do that with us as well. We can enter into a contract where the state of Colorado lets them into some state funding or some state programs, and they accept the conditions that come along with that. What does that mean for us? Here, in exchange for participating in Colorado's public school system, the tribe has agreed, we've worked out this portion of the charter contract, the tribe has agreed to follow all state and federal laws that regulate institute charter schools unless waived. Now, some of those laws are not particularly consistent with the concept of tribal sovereignty and are perfectly appropriate for waivers in our opinion at CSI. And the need to be a little flexible with those laws is really what makes the Charter Schools Act such a great fit for this project. So here, we're going to be submitting all of the usual waivers. So the normal things that almost every charter school in the state of Colorado requests. You'll get those from us here next week. But we're going to have sort of a list, and I've broken this out into 9 topics, but this reflects maybe 12 or 13 waivers that you guys either rarely see or never see. They're all waivable statutes, but they don't come up very often. And I'm going to walk you through sort of the reasoning behind these waiver requests now. And you can ask me questions about the state law, and if we need to talk about the replacement plan or really the tribal culture and sovereignty issues that underlie these waivers, Peter is available. So to begin with, we have marijuana, tobacco, and peyote. So under Colorado law, students have the right to access medically prescribed marijuana. You're familiar with this. You promulgated rules to implement Jack's Law, as it's known. Reflecting a somewhat different policy rationale, Colorado has very strict prohibitions on the use or possession of tobacco products and of psychotropic drugs on school property. It turns out that on both of these sort of different policy theories, the tribe takes a different position. So they do not have legal medical marijuana on the Mountain Ute Reservation, and since Colorado law doesn't apply there, federal law is the only one that does in tribal law. And as you know, under federal law, pot's not legal, even for medical use. Separately, under federal law, there is a statute that allows tribes slightly more leeway for religious or spiritual customs or practices that happen to involve some ceremonial use of tobacco or peyote. And this school, because it intends to be a culturally sensitive and inclusive school, intends to be richly informed by Mountain Ute cultural practices. They're going to be teaching and demonstrating some of that stuff, and they just want to make sure that they can use the tobacco or the peyote in demonstrations in the classroom as need be. As a practical matter, federal law is going to trump us on this one anyway, so this waiver is arguably not necessary, but we're going to ask for it just to make sure that the lines of responsibility and that the law that applies to this school is very clear. Next up, nonprofit corporation status. So since 2012, charter schools in the state of Colorado have been required to organize under the Colorado Revised Nonprofit Act or Nonprofit Corporation Act. The law of business organizations is by and large a state law thing in the United States, which means that our law doesn't really govern tribal organizations. And the tribe, it turns out, has its own law of business organizations, and that law includes nonprofit tax status. So we're going to ask for a waiver just to allow the tribe school to organize under its own law of corporations rather than our law. CSI doesn't have any objection to this. We think this is well within the normal range of charter autonomy. It's just unique because we happen to be doing something in some other sovereign nation, which is kind of fun. State building, fire, and safety codes. As some of you are aware, because we were dealing with that Windsor matter here for the last several months, Colorado at the state level preempts local city and county planning and zoning codes. We have a state level building and safety code system promulgated by the Division of Fire Prevention Control and the Department of Public Safety. For those of you who've worked in administration at the district level, you probably still see the local building inspectors come by. But when they do that, they're not doing the county or the city codes. They're enforcing the state level code, just they're contracted through the state to do that. If you went to the Montezuma County building inspection office and asked them to go onto the tribe to inspect a public school, they would probably look at you like you had three eyes. Because they do not have that sort of a relationship with the tribe. They don't go onto the reservation to inspect things. We see no reason to try to start that from scratch. Try to start that local and state relationship with the tribe for building inspection purposes. The tribe has its own building and safety codes. A lot of that is driven by federal law when they take federal grants to build things. And we have no reason to think that those codes are inadequate. So we're going to ask you for a waiver that just allows them to apply their own building and safety codes. Student publications, this gets a little less dry, maybe a little more interesting. So as the Supreme Court has interpreted the First Amendment, schools, generally speaking, have a great deal of control over what is published in student newspapers that are hosted by the school. So there's a fairly low standard there under the First Amendment. Many states, including Colorado, responded to that ruling by adopting a statute that imposes a slightly higher standard, gives students greater control, greater free speech rights over what they publish in the school newspaper. The tribe has taken a look at our statute, and they, under their own cultural traditions, would like to set the standard just a little bit more restrictively, still well above the First Amendment standard, so still highly constitutional here. But the school would like a little bit more control over the publication than Colorado law would normally allow. And we thought that was reasonable, so we're going to bring forward that waiver request at the tribe's request. Next up, CPR training for coaches. So Colorado law requires all athletic coaches to be trained in CPR and in the use of AEDs. This waiver request is mostly just a function of legal clarity. So the tribe will be, the right way to say this, the school will be using the tribe for most of its personnel needs, which means that, for example, they're going to be sending their kids down to the tribal rec center for most athletic activities, which means that there is going to be some people there at the rec center who are not school employees. They're tribal employees who aren't affiliated with the school. They have their own life safety training. At CSI, we have no reason to think that life safety training at the rec center is inadequate. And so just to clarify who this statute does and does not apply to, we're just going to ask for a waiver allowing the tribe to use its own life safety routines and trainings. Title 22 crimes. That title that I put on this slide is probably a little broad because only one of these is actually a crime. But under Colorado law, it is a misdemeanor crime for a student to make a false accusation against a teacher. Also, under Colorado law, the local district attorney has the authority to go to court for truancy actions. Now, it is a long-standing question of sovereignty. The tribe is not subject to our criminal code. The tribe is generally not subject to our court's jurisdiction. At the moment, the Montezuma County courts do not try to enforce truancy actions against the students from this reservation, as I understand it. And the tribe already has its own criminal statute, making false accusations illegal, making a crime, a misdemeanor. This is about as core, these matters, criminal codes and court jurisdiction are about as core to the topic of sovereignty as you can get. And we see no reason to try to push anything here. We think the tribe's truancy plan and the tribe's criminal code is more than adequate to meet the intent of these statutes. And so we're going to ask you for a waiver from these two as well. Getting back into the tricky stuff, public posting of documents. There are two statutes that require charter schools and school districts to post particular types of documents on the school website. One of them is the Student Data Transparency and Security Act. It requires schools to post all of their data service contracts to their websites. So this is like when you contract with Google Drive and the Google suite of documents to do your schoolwork with and your cloud storage, you have to post your Google contract on your website. Under the Financial Transparency Act, schools also have to post their budgets, their annual financial audits, their salary schedules, a small list of other documents up on their website as well. This gets into a little bit of the corporate law ambiguity with the tribe because their corporate law and the degree of separation between the school and the tribe is not quite what we're used to thinking about under American law of corporate organizations. And then also, more broadly, the tribe has a more restrictive approach to the public posting of its business documents, even though you and I would look at those and think that they're government documents. We had a long conversation about this. The CSI board and I talked about this forever, and Peter, the tribe's attorney, and I talked about this for quite some time. And we came to an agreement where all of these documents can just be posted on CSI's website as a replacement plan. And so it should be the same degree of transparency. It just takes one or two more mouse clicks to get where you're going if you're trying to find these documents. We think this is a reasonable compromise, and we're going to ask you for the waivers to implement it. PIRA, this one again is mostly a matter of clarifying the law. So I mentioned earlier that the school intends to contract with the tribe for most of its personnel needs. So this would be sort of similar to schools that are getting all of their or some of their employees on an independent contractor basis from an ESP, from an education services provider. In that sort of a situation, the school doesn't actually have its own employees, and therefore, it's arguably true that PIRA doesn't apply to the school. It's even more true here because the tribe is not subject to PIRA at all. And so we're going to ask you for a waiver from the provision of the Institute Charter Schools Act that says the CSI schools are PIRA employers. Without that, or with that waiver, without that statute, there shouldn't be any legal ambiguity whatsoever about who is and isn't in PIRA. And as Peter can explain, if you want, the tribe has a very generous 401k system, and I anticipate you'll have some questions about this one, but we'll be prepared to answer those here in just a second. I've got one more slide, and this final slide is a group of things that I would describe as teacher loyalty oaths. We have a variety of statutes imposing various types of teacher loyalty requirements. Most of these statutes stem from various Red Scares or waves of Red Scares over the past 100 years in American policy history. So one statute that we have, its current version just requires teachers to swear an oath to the U.S. and Colorado constitutions. That's a little bit of an issue for tribal sovereignty purposes because the tribe is not subject to the Colorado Constitution. They've proposed a replacement plan where they just swear allegiance to the U.S. and tribal constitutions, and that seems reasonable to CSI. Another one of these statutes prohibits schools from inquiring about teachers' religion at all, and the tribe, because it intends to have a rich curriculum in which it discusses the tribe's cultural, religious, and spiritual traditions at some length. They would like teachers who know something about it, so they intend to ask some questions about basis of knowledge during their hiring processes. And again, that strikes us as a relatively reasonable waiver and replacement plan. And then finally, we have a statute that prohibits school districts from requiring teachers to be a member of any given organization. And the tribe has longstanding hiring preferences for enrolled members of the tribe. Again, we think that's a fairly reasonable waiver to ask for to allow them to maintain those preferences for enrolled tribal members. So those are all, and I know I did that very fast, those are all the unique waivers. I'm going to stop sharing my screen now. If I can remember how, and then open it up to you all for your questions, your feedback, any suggestions you'd like to see before we come back to you with these, with a formal waiver requests next week, or next month, but we'll submit them next week. All right, that was a lot of information. Sorry about that.
Thank you, Mr. Peters. I'm going to go down the line to give colleagues an opportunity to make any comments or ask questions. Board Member McClellan.
Thank you, Madam Chair. I'm just wondering, does the waiver of the CPR training requirement carry any possible liability for the state board or for the department?
I cannot imagine a way to trace liability to CDE or to the state board. I can't even imagine a way to trace any liability to CSI for that one. Charter schools are separately incorporated legal entities for that very purpose of cabining any kind of liability at the school level.
Thank you.
Board Member Escarzaga?
Thank you, Madam Chair. I had just a couple quick questions. And I'm sorry, I saw 8 requests for waivers. I numbered them on here and didn't put titles, so I'm gonna ask by number. For number 2, will the school be a nonprofit then, essentially, for federal tax purposes?
Yes.
Okay. Number 4, which would be the student publications. I think I just have a curiosity on why they wanted to have this waiver.
Peter, I have to pitch that one to you.
Sure, no problem. Thank you for the question. One of the things I've learned as I've been working for the tribe over the years is that there are very specific ways about how to speak about certain things. And they're not the typical kind of issues that you might see at a school where you're talking about some type of criminal liability or some type of civil liability that a student may incur for what they speak about. That would naturally apply here in the reservation as well. But it's more of a cultural issue about when certain things can be discussed and how they're to be discussed. And so the publication will be operating under, if there is a publication for the students, I believe there will be at some point, it's going to operate under sort of those types of guidelines. So it's slightly more restrictive, but it still allows free speech and allows the students to express themselves so long as they do it within the cultural framework. I'm not aware of anything that could not be discussed, that would not, and I think anything that a student would be able to say in a charter school publication, they would also be able to say in this publication. We would just sort of coach them about the proper way to say it and how to go about doing it.
Okay. All right, number 6, that's the, where am I? Or I'm actually the posting of documents. So it'll all be on CSI's website. Will there be a link on the school's website? So if somebody goes looking for it, they can just hit the link and it directs them to CSI? Or if there'll be nothing on the school's website and then they'll have to think that it might be on CSI's and go figure it out themselves?
That's an excellent question, and I have been meaning to follow up with the tribe on that to see if they would be amenable to putting a link on their website. I have not yet done that. And Peter, I don't want to put you on the spot and make you commit to anything at the moment, but Dr. Escarzaga, can we get back to you with whether or not the tribe is willing to?
Sure, because a lot of the rural districts and districts in our state just have a financial transparency button. And I can guarantee you I have gone to all 178 school district websites for a task I was doing for the commissioner, I think it was a year or 2 ago. And they are all there. And you can just click the link and then it goes to all the information on the state's website. So it's relatively easy. And then my last question is just on the last waiver, the teacher oaths. I take it that the AG's office doesn't see a problem with this at all, right? That I don't know if we've actually asked them for a formal piece, but they don't see that this is going to be an issue, civil rights issue or anything like that, that they say this is an allowable waiver that could happen?
Yeah, I did not, I haven't asked for a formal opinion from the constitutional law experts within the Attorney General's office. Speaking as CSI's attorney and not as your attorney, I will say that I did not see anything here that struck me as falling below the First Amendment floor, right? It is normally true, for example, as you know from your background teaching, you can discuss religion in the classroom as a cultural and historical matter. You can talk about what the Bible is and what the history of Christianity or the Quran and Islam is. What you can't do is proselytize in the classroom. And I'm not under the impression that this school will be crossing those limits. And in fact, this school will be bound by the First Amendment just as much as we are.
Okay. That's it for my questions. Thank you.
Thank you so much. Board Member Scheffel?
Yeah, thank you for the presentation. Very thorough. Really appreciate the explanation of the waivers. I just had a question, and this may not be, really in the purview of this presentation, since I know it's linked mostly to the waivers and explaining them, but I noticed the curriculum's project-based. And so as far as the assessment of learning, is that appropriate to talk about, or is that in a different presentation? This doesn't relate to a waiver. I just wanted to know how the school's going to assess learning and closing the achievement gap, since that's one of their main desires.
So speaking for myself, I would be more than happy to pitch that to Tina or Richard to speak to, but Dr. Schroeder, I think we're good 10 minutes over our time ready. Would you like us to reserve that question for some other time?
No, let's go ahead. Let's go ahead and give this the time it needs, please.
All right, Richard, Tina, would anybody like to address that?
Yes. This is Tina, and we plan to follow just like the other schools in our region. We will follow the Colorado standards and make sure that we're reaching every standard, but doing it in our project base. And Richard, you can follow up on that if you wish.
Yeah, we plan to have all the, I would call normal READ-ACT and CMAS assessments, and all of the, there is no waivers, I guess I could clarify, around assessments. So I don't think you would see anything unusual in the academic assessments at the school.
So you still do progress monitoring and all those kinds of things. It's a little challenging to do that in the context of this model, but it's a great model if it's tight, and it's very compelling to students. So I just had a question about progress monitoring. You mentioned the READ-ACT.
Yeah, we would be, we plan to use AIMS-Web, which is one of the READ-ACT measures. And so we would use that as an example. And we're, looking at things like everyday math, Wonders, Reach, number of more traditional programs that embed progress monitoring within the reading and writing and math curriculum. And so then we'll also work, AIMS-Web is used by the San Juan BOCES, so that will be good markers for indicating if there's any significant reading deficiencies or linked to any of the individualized learning plans.
Okay, great. Thank you. I appreciate the presentation. Sounds like a compelling model and a great opportunity for students. Thank you.
Board Member Rankin.
Yes, thank you, Madam Chair. My first, and it's kind of a high level question, has to do with the history. How did this come about? And did we say that district does have other charter schools? They're an authorizer, but they gave permission for CSI to come and join together. Just a little bit of history, how this all came about and how it started.
Yeah, so I'll start and then probably pitch it to Terry might be best. So first, from the legal perspective, yes, the district has released exclusive chartering authority for purposes of this one application. Much as we have, I think most of CSI's portfolio is by agreement rather than by loss of UCA. Past that, Terry, do you know, does Montezuma-Cortez have other charter schools?
They do. They have 3 other charter schools. They've been chartering and doing authorizing for quite some time. And so it was 2 things. One, the group itself, I think, has been working on this project for quite some time, and worked with the league for a while and other entities that have come together to really work on forming the project and the plan. And then in terms of the relationship with Montezuma-Cortez, we worked with them. They reached out to us and had conversations. I actually went down there with some other CSI staff. We visited the reservation. We met with Montezuma-Cortez board and talked about what we could provide in terms of technical assistance and what authorizing might look like through us. And we committed to having lots of transparency, and a partnership with the district has worked very well. But yes, they do authorize 3 other schools.
Can I go back to the question again? How did this come about? How did it originate again? You may have said that, Ms. Lewis, but I didn't quite hear it. It was breaking up.
Oh, sorry. So, yeah, Richard and Tina can talk a little bit more about how long this project has been kind of in the works, if you will. I know this is not a new idea. It's something that they have been discussing as a tribe for quite some time and have reached out and worked with different groups over the last few years. So it is something that it just all came together in the last year and a half. That they were really prepared to submit an application to a authorizer, to either the district or to us. But I can pass it to Tina and Richard, and maybe they can provide more details on that.
This is Tina, and yes, I am the director of the K-12 education, as you well know, and working with the schools since I've been here in this position. We saw that different things were needed for our students that the school district didn't have in place. And not that the school district was bad, it was not. But through working with them and through some of the legal things that have happened throughout the years, just little things, that Peter and I both thought, you know what, we could do a school down here. And the idea came with both of us. And just seeing little things, and then the idea came together. We started the design team and just thought, we can do this. We can put together a school here that they don't have to go to Cortez, because many of them say, yeah, I go to school in Cortez, but they don't feel it's their school. And you know, if you're going to succeed in education, you have to have a heart for, this is my school, this is what I'm going to do. If you don't have that, then you're losing from the very start. And Peter and I realized that and thought, you know what, let's work on this. Let's see what we can do to help these kids to have a school in their own home that they can feel proud to go to. And that if they have an issue, they can come and say, hey, how come we can't learn about this, or how come we can't learn about that? Whereas standard public schools, you can't do that. You know, it's the curriculum, it's what you do, it's how you do it, and everybody has to do the same thing. And we thought, you know what, we can still stick with district standards. We can still do everything we're required to do to make sure our students are learning and growing, but we can do it in a different way, and we can do it in a positive way here in their own home. So that's how that came about. And our design team started 2 years ago, and we just have grown from there. And I think we put together a really good plan. I think we're on the right track. So we're hoping it will be successful. Did that answer your question?
Well, not really, but I will come back to it. You say the team, are these parents, are these 2 or 3 parents that started, got other parents? Usually that's the way a charter school begins, or were these maybe a couple parents and then they went to the outside? I believe there was some after, and the commissioner can help me with this one. There were some after-school programs for tribes in that area so that they could teach the tribal language, and the tribal leaders were the only ones that, that were so well versed in the language that they could do it. But it was an after-school program, and people didn't sign up for it. I just know this is a unique situation, but is that the core basis, is to carry on traditions and things that maybe are lessening throughout the years? Give me a little background on that. And is it parents that started this, or a team of who in the district?
Okay, I can do that. Yes, there were parents that Peter and I had talked to, not very many, but from us just working at it and having after school, we had the STEM project that came down from CSU. And they helped us, our regular 4-H company here, or not company, organization came down and we're doing different things with us here. And our own recreation started doing programs in the summer. And we just saw a need. And so we partnered with Fort Lewis College. That was the big key, is Fort Lewis College, with getting things over here to help us. And so Peter and I worked with a few parents here, and yes, there were many people who said, we need our own school here. We need to see what our kids are doing here. so we don't have to drive that 15 miles to or 12 miles to Cortez. And they weren't the push. It was more Peter and I, the push. And then we teamed up with Richard, and then Sherelle came along with NACA. And NACA was really the big push to say, okay, if you want to do this, let's do this. And so we did that, but we have many, many families and parents who are very excited about this school. So no, it wasn't all parents.
If I could jump in very briefly, Board Member Rankin, obviously this is your district. We probably should have reached out and done a one-on-one with you before we came here today. I'd be happy to set up a one-on-one with you. I'm starting to worry more and more about the commissioner and the board chair being very angry with me for the schedule right now.
It's okay, Joe. It's okay.
Okay, and I would definitely like to talk further, because every time I have a question, I get 10 more. But I still have a couple of big ones that maybe other people are interested in. Are there any other states that have similar type of situations? Not exactly, because we're all different, but have started these kinds of schools, Joe?
There are. I'm aware there's several in Oklahoma. I believe there are some in Arizona and perhaps New Mexico. I know South Dakota is working on setting up a tribal charter school right now. And I have unsuccessfully reached out to my attorney counterparts in all of those states. None of them have chosen to get back to me. But my understanding is that Sherelle, Tina, Richard have been working with their school level counterparts in those states.
Do they, I'm looking at the higher level, the state level, do they have like waivers like we do? And are they maybe struggling or did struggle with some of the similarities? And also, going back to Board Member Skarsiga's question, there's 8 waivers there. Can we approve some and not others? Will that ruin the whole program? These are some legal questions, I guess, that I have.
Yep, and I can address each of those. So every state does waivers slightly differently. Colorado, I would characterize as being on the relatively more restrictive side. So in some states, charter schools sort of start with a very, very broad blanket waiver. It says charter schools are subject to none of our title, our education code, except the following, right? And then they list the laws that regulate them, and it's like accountability and student safety and stuff. Colorado's sort of the polar opposite almost, where we say you are, by default subject to all of the laws, except for those that we specifically waive on a case-by-case basis. And some states are slightly more restrictive than we are just because they don't have that list of automatic waivers. So there's a sort of a spectrum in how automatic the release from many state laws are. Colorado's on the relatively more restrictive, relatively more heavily regulated side of the charter sector. And as I mentioned, in the other states, Oklahoma, South Dakota, Arizona, the attorneys at the SEAs in those states didn't get back to me. I traded a couple of emails with Oklahoma, but South Dakota, I spoke on the phone with my counterpart, and she wasn't engaged in that project at all. And South Dakota is a little unique because they only have tribal charter schools. They don't have any non-tribal charter schools in South Dakota. So the answer to that is that it's all just so unique to this underlying state charter statute that I wouldn't expect anybody to have too much to offer me, really. And then to your other question on picking and choosing, yeah, the state board, I believe under the Charter Schools Act, unlike innovation schools, under the Charter Schools Act, you can grant some but not all from the list of waivers that's presented to you. Whether or not your decision to deny some of them turns into a deal breaker for the tribe is a conversation that the tribe and CSI can have if and when it arises.
Okay, and since this is a sovereign nation, why couldn't they just have their own school there? Why are they doing a charter school? I'm a little confused on that one.
In order to participate in our K-12 education system. So it's for state money, right? We have 2 reservations in Colorado. The Southern Mountain Utes is the other one, and they have their own schools, and they don't participate in our system at all. So this is, this is a spending clause sort of thing, right? We're going to let them participate in Colorado's system, and they're going to, excuse me, agree to as many laws as they need to in order to participate.
Okay,
and Peter,
they could do that.
Yes, they could have their own schools. Peter, if you'd like to correct me on anything I just said, please let me know.
Yeah, for the tribe, the real issue there is the accreditation issue. There are various ways the tribes can form schools on their reservations, one of which is under their own authority. However, the issue there becomes accreditation and whether we would be able to ensure that our students were meeting the standards that are required for higher education.
Okay, I'll go on to my next question, and it kind of maybe dovetails that one, and it is understanding the academics. I hear on the front end of this, everything's great, we're going to do this, we have great people, we're linked with the college and everything's good, but when we get right down to Board Member Shuffle's question about language, is this going to be somewhat of a dual language to learn the tribal language too as they progress? Having a project based and then not having the transparency maybe that we have otherwise with test scores and academic achievements and whatever, it's a little vague to me. I'd like a little more concrete with core actual teachings and academics. Is that going to come out next month, or
I don't believe there's
can someone address it?
Yeah, I'll start. I don't believe there's any restriction or changes to the level of transparency on academic stuff, right? So we talked about moving where the public posting of certain financial documents are and data contracts, but all of the assessment data, all of the academic stuff should be unchanged from what you would see at any other charter school. Past that, moving into the more core educational questions, I'll need to pitch that over either to Terry or to Tina and Richard.
This is Tina. We are including our language in the school because we're one of the tribes who is losing their language. And we want that to be a part of the school so that we don't lose that language, because when you have another language, many things are tied into that language which cannot be reproduced in English. We don't want to lose that. So we want to save that, we want to encourage that, but we are also doing English learning, but we don't want to lose our language. That's one of our needs here, and that's one of our desires, is to keep our language alive.
So what percentage of time is spent on one language and the other, and what percentage on the other do you anticipate?
We are going to have classes in Ute, but we have not figured out that percentage as of yet. But English will be the main language at this time. But we don't want to lose our language, and we don't have that in our plan right now, but we will have.
I would quickly add in our application, this is Richard Fulton, in our application, one of the ways that you might be able to visualize this is you would have, a language block in the morning for an hour and a half, you'd have a math block for an hour and a half, and then in the afternoons, students would go to Ute language and culture class, much like they might go to PE as sort of a specialized topic, and then they would go to music and PE after that. So you might visualize it somewhat as, on one level, as one more elective, but then at a deeper level underneath that is going to be obviously some ways in which you would have, as students go through a normal day, they might see the pronunciation of Ute letters, or if you're studying about the seasons or the sun, you would also learn what the Ute significance and words are for the seasons, as an example. So I think where possible, there will be a lot of purposeful integration of culture throughout the day, but with focused times for the language and culture, if that helps visualize what a school day would look like.
Thank you. Thank you for that. It does help. And I'm going to hold off on any more questions. Joe, I'll get back to you too.
Absolutely.
Thank you. Board Member Esser?
Thank you, Madam Chair. I think most of my questions have been asked, Joe. The only question I have is about that para waiver. Does that assume that the tribe will take care of any type of retirement should a teacher be employed for that amount of time?
Yeah, so the tribe has its own 401k system. It's probably one of the more generous ones. And if you'd like to see further documentation on that, like the actual 401k plan, some of the financials, would be happy to produce that, I believe.
That would be great. Thank you, Joe. That's all I have, Madam Chair.
Thank you. Board Member Durham?
No questions. Thank you.
Thank you. Any other questions, colleagues? So I do have a question to my colleagues, and that is when this comes back next month for the waiver request, is this something that we can put on the consent agenda, or are we talking about asking them to come on the agenda again? Or could you speak up?
Madam
Yes.
Chair, I'd be comfortable having them on the consent agenda.
Okay, so this is a charter that's been approved by CSI. This is really only about the waivers that have been requested. If there are specific waivers that you want to dig in some more, I would suggest you speak up and give us a heads up so that we can be working on that on behalf of the school. Otherwise, I would suggest we put it on the consent agenda. Board Member Rankin, I see you.
Yes, I can't answer that question right now because I'd like to spend some time with Joe and hear about other states. I also I think need a little more clarification on some of the rules according, or the waiver, the peyote and the tobacco, and that I have questions there just as to how the feds, some of it's very, I need a little clarification, so I'm not going to answer that.
Sure. Okay.
For
so
consent agenda.
It's not part of our normal work that we do, so I can certainly understand. So colleagues, maybe it would be helpful if you would let, in the next, I'd say 2 weeks, let the commissioner's office know where you are on another separate discussion, or whether you're ready to put it on the consent agenda. Does that sound okay to everyone? Great, thank you. Thank you, Mr. Peters, Ms. Lewis, Ms. Sanchez, etc. Appreciate your presentation. Wish you well in case we're not front and center again. Thank you very much.
Thank you very much. Appreciate your time and questions.
All right, are you on for the next thing also, Joe? Are you training us today? No, I guess not. Next item on our annual board training is HB 1198, requires each statutorily created board or commission in state government to obtain an annual training on specific topics. Because we're not statutorily created, this requirement does not actually specifically apply to the State Board of Education. However, in recent years, we've agreed to an annual legal training be consistent essentially with best practices and helpful for the board. Ms. Zrilnik, what do you have for us? I was wrong, it's not George, not Joe.
Thank you, Madam Chair.
Go ahead.
All right, I've got a PowerPoint. Are you able to see the first page of my slides?
Yes, I see it very well.
Thank you. So just as an intro, today I am presenting on laws and best practices that govern the State Board. And you've already mentioned that this statute about best practices and training does not technically apply to the State Board, But you've opted into this annual training essentially just as a best practice because it is a good idea. So that's why we're here today. And I have about 25 minutes of information to present. Feel free to jump in at any time with questions, or you can wait till the end and we can discuss questions then. Here's today's agenda. Instead of boring you right away with the open meetings and open records laws, I'm going to back up a bit and start with discussion about this board's origin and its legal authority. And that's why the presentation was titled The State Board's Role in the Universe. These concepts related to the board's roots and its legal status really inform your work and where your authority flows from. And then, not necessarily among all of you, but certainly in the public, sometimes there's confusion around where this board fits within state government. So we'll address that as well. And then we'll look at some of the key laws and the state board specific governance documents. So the reason that best practices statute doesn't apply to you is because this board was not created by a statute. It was created by the Colorado Constitution. And the Constitution provides that the general supervision of the public schools of the state shall be vested in a board of education whose powers and duties shall be as prescribed by law. In other words, the Constitution gives you general supervisory power over public schools, and it gives the legislature the power to prescribe those specific powers and duties you have to carry out your supervisory role. So before we move on to those specific powers and duties, I want to talk about this general statewide supervisory role a little bit. That provision in the Constitution is kind of vague. So what do we actually mean when we say that the Constitution gives you general supervision over the schools? Judicial decisions have explored this question. The main case that discusses the state board's role is a Colorado Supreme Court case from 1999 known as Booth. In Booth, a local school board claimed that the charter appeal statute was unconstitutional because it allowed the state board to order local boards to authorize a charter school after the local board had already rejected the charter application. The court went through a lengthy analysis. It examined the constitutional roles of local boards and the state board. And ultimately, the court held that the charter appeal statute struck a balance that respects the constitutional domains of local boards and the state board. Therefore, the statute is not unconstitutional. So to get a better sense of what the state board's supervisory role entails, we can look at some of the court's statements from this Booth case. The court said that the constitutional framers intended for the state board to serve as both a conduit of and resource for educational information and policy. So in other words, you all are the state's elected education policy experts. The court described the board's role as providing direction, inspection, and critical evaluation from a statewide perspective. And the court recognized the legislature's broad authority to delegate powers and duties to the state board that are consistent with its supervisory role. So this Booth case just helps us understand what the Constitution means. But admittedly, even this case law is still a bit vague and esoteric, but our discussion is about to get more concrete. The state board's duties and powers are set out in Colorado's Education Code. The code is Title 22 of Colorado's state laws. I've got the citations listed on this slide in case you're bored enough at home to pull out your school laws book and do some reading. But these are just some examples of some of the main duties and powers in these statutes. Next, a reminder of the state board's mission and vision statements. The board sets these statements for itself. They're found in your operating procedures. And my understanding is that the board has not updated its operating procedures recently, but is going to be looking at those and updating them this year. So that would be an opportunity to revisit the mission statement and vision statement if you wanted to. Okay, moving on and continuing to get less esoteric as we go. Here are some of the main ways that the board carries out its supervisory role on a day-to-day and month-to-month basis. They range from adopting rules and standards to serving as the decision maker in certain education matters, and using your subject matter expertise to make recommendations to the General Assembly and the governor. Next is a quick look at where the state board fits within state government. We've got the three branches of government. The executive branch includes the governor, the attorney general, the secretary of state, and the treasurer. State agencies, including CDE and the state board, also fall under the executive branch. But this slide says sort of at the bottom because the governor does not have direct managerial control over CDE or the state board. Many of the other state agencies are led by governor-appointed executives. So CDE and the state board are a bit unique in this regard. State board members, as you know, are elected, and then the state board appoints the commissioner of education. So when the governor issues directives that concern the internal management of the executive branch and agencies, we typically take a close look and consider whether that directive governs CDE and the state board, since they're not under the governor's direct control. CDE is what we call a principal department of state education. And in addition to the state board, there are a few other type 1 agencies that are housed at CDE. They include the BEST Board, the Colorado School for the Deaf and the Blind, the Charter School Institute, and the Facility Schools Board. Type 1 agencies are mostly autonomous from CDE. All of these Type 1 agencies have their own governing boards with their own rulemaking authority, and CDE does not have general management authority over them. They're essentially self-governing. Since we talked so much about state supervision, I'd be remiss not to mention local control. Local control is a term that's frequently thrown around and often misunderstood. But similar to how the Constitution assigns statewide supervision to the state board, the Constitution gives control of instruction of the schools within each district to the local boards. So that's what people are referring to when they say local control. It's the constitutional provision that says local boards have control of their districts. And this balancing act between state and local control over public education is a common theme in litigation as well as legislation. Sometimes local control is kind of weaponized and thrown up as a bar against state action or state regulation, but it's actually much more nuanced than that. In the Booth case, the Colorado Supreme Court established a standard for how we reconcile state and local control. And the standard is that the state may limit local board discretion by statute or judicial review, but the state cannot completely usurp local boards' authority or the ability to manage their own schools. Moving on to some of the state laws that govern board operations, we'll look at the Open Meetings Laws, Open Records Act, and the State Code of Ethics. Colorado's open meeting laws are referred to as the OML or Sunshine Laws. Every state has some form of sunshine laws. Their purpose is transparency. Government business should be conducted in public, not behind closed doors. And the OML's basic requirements are public meetings, keeping minutes that are open to inspection, and limits on when you can meet in closed session. Big picture, the premise of the OML is that if you're talking to another board member about board business, the discussion is supposed to take place in public at a meeting. So if 2 or more board members discuss public business, that's a meeting that must be open to the public. So what really makes a meeting open to the public? Generally, we say that that requires notice with an agenda telling the public when and where they can watch and what topics are going to be discussed, and then adhering to the legal limits on when executive session is allowed, which we'll discuss in a minute. Here are some example scenarios. The first is just a rulemaking session and a work session. Yes, that would be a public meeting. If board members get together for dinner and drinks, it's just a social gathering, you're not discussing board business, that would not be a public meeting. You're allowed to socialize. You have a phone call to Angelica with a question about the agenda. That's probably not going to be a public meeting because you're really just talking about scheduling and administrative matters. You're not talking about substantive content that needs to be discussed in public. Side conversations between board members on a bathroom break. During a meeting about a rule, yes, that's the type of discussion that should be had during the meeting, not over to the side. Phone call to Steve with a comment about a rule, same outcome. That's the type of discussion that should be had at a public meeting. And the last one, a phone call to Julie, your attorney, with a question about procedure. That's definitely not a public meeting covered by the OML, primarily because Julie's not a board member. But also because the discussion most likely is subject to attorney-client privilege. These are the substantive and procedural rules for executive session. You can only go into exec for certain reasons that are listed in the statute. Some of the common examples are for legal advice or certain personnel matters. You cannot take formal action when you're in executive session. You have to come back out and vote in public. The law has procedural requirements to go into exec. You must announce the specific topic for discussion in closed session. There must be a motion and 2/3 vote, and the session has to be recorded. So 2 Colorado cases about the OML came out within the last year or so that are worth a quick mention. In this first Doe versus CDPHE case, the district court held that the Colorado Department of Public Health was a state public body subject to the OML. Both the Court of Appeals and the Colorado Supreme Court disagreed and held that the OML does not apply to the Department of Public Health at large. The statute only covers state boards and commissions. And in that case, I think the district court's decision was pretty obviously wrong, but it's still a reassuring outcome for state agencies. The second case is Guy versus Whitsitt. This opinion came out in June. The Colorado Court of Appeals held that a town council violated the OML when it failed to announce the topic for discussion before going into executive session. As a remedy, the court ordered the town council to provide the entire recording of its executive session to the plaintiff. And this case raised some flags for people because the recording that the court ordered for disclosure apparently included legal advice. And some lawyers think there's a good argument that the legal advice portion of the tape should have been privileged and not subject to disclosure. But it looks like this case settled and won't make it to the Colorado Supreme Court, so we might not get clarification on that point yet. But I still mention it as a cautionary tale that for OML violations, the remedy could be public disclosure of the entire closed session recording. Moving on to the Open Records Act, known as CORA. CORA requires that state agencies make most public records available to the public upon request. Public records include any writing made, maintained, or kept by an agency, but then there's this long list of exceptions in the statute. Some examples would be things like emails with your attorney, agency security plans, certain types of criminal justice records. So the basic principle of CORA is that if you're writing about public business, the public is entitled to see the document unless an exception applies. And for most boards, emails are the most common public record to keep on your radar. Any email you send that concerns board business is likely a public record. For example, if you email Dr. Anthus about board business, that's a public record that would be subject to a CORA request. And even emails you send to people who are not public employees could be subject to CORA if the email concerns public business. For example, if you email a constituent or a friend about board business, that email could be subject to a CORA request. On the other hand, if you're emailing with another board member and it's strictly personal, you're just talking about your kids or your vacation, that would not be a public record. So some best practices for CORA. It's a good idea to use your state board email address rather than a personal one when you're emailing about board business. That way, when the board gets a CORA request, you don't have to search through your personal emails and parse out what's what, ideally all of your board emails would be in the state board account. You can copy Angela on any board related email that you send, then she's got a copy. And when you're emailing, remember that any email could be published in the newspaper without any favorable context. Lawyers sometimes tell their clients to dance like no one's watching, but email like it will be read in a deposition. That's also good advice for board members. Keep emails from the board's lawyers confidential. And if someone sends a CORA request to you, just forward it to Angela as soon as you can. Don't try to respond to it yourself. Moving on to ethics, Colorado law contains ethical standards of conduct related to government service, but most of the provisions in the state code of ethics don't apply to the state board just because of the way the code defines public officers. Most of those provisions don't include you, so the state board has adopted its own code of ethics, and its content is very similar to what's in the state laws. These are the provisions in state law that do cover you. The first is a general statement about public trust and carrying out your duties for the people of the state. The second one prohibits board members from performing official acts which may have a direct economic benefit on a business or other undertaking in which the member has a direct or substantial financial interest. The statute doesn't use the term conflict of interest, but that's what this really is about, financial conflicts of interest. The next slide is more on the same conflict statute. Just note that the statute applies to apparent or potential conflicts, not just actual conflicts. Financial interest includes things like investment and employment, but it would not include personal interests or political interests. And most of the rulemaking that the state board does not even present an opportunity for anyone to directly financially benefit, so these conflict situations should be rare. As I mentioned, the state board has its own code of ethics. It's only about 5 pages long and it's pretty straightforward, but it does address more than just financial conflicts. It also prohibits outside employment that is directly incompatible with the discharge of your official duties. And this ban on incompatible outside employment is not unique to this board. It's a concept that's also in state law and governs state employees. Then just a reminder to disclose any conflicts early, refrain from voting, refrain from participating in board discussions, and don't try to influence other board members if you do have a conflict. Next, we're just going to run through the state board specific governance documents. The 2 main governance documents are the operating procedures and the code of ethics. Then you have a whole host of other operating procedures on various specific topics, and I'll list those and give you links to where they're located in a minute. First, the state board's operating procedures. These procedures govern and control all board actions. Consistently following these procedures is always a good idea to promote fairness and transparency as to how your meetings are going to run on a monthly basis. And these are the topics addressed in the operating procedures. It's just very basic governance and board meeting procedural information. These are the topics in the state board's own code of ethics. If you haven't looked at this one in a while, it's a good one to reread, and it's pretty short. Now here's a list of the subject-specific board procedures. You have procedures for charter school appeals, exclusive chartering authority determinations, accountability actions, state board activity in relation to legislation. In other words, when the board is taking a position related to legislation as a board. Petitions for declaratory orders. This one warrants an explanation because it comes up so infrequently. There's a statute that says every agency shall provide rules for entertaining petitions for declaratory orders to terminate controversies or remove uncertainty as to the applicability of agency rules or orders to the petitioner. So a person or a school or some other entity could file a petition essentially asking you to clarify whether a certain state board rule or order applies to that person or entity. Guidelines for public comment. These are not true procedures, but I thought they're worth mentioning just because public comment is on the agenda at every regular meeting, and it's one of the most direct ways that you interact with the public as an entire board. So again, following your own procedures consistently is important for predictability and fairness in relation to how and when you allow public comment. There's a travel and expense policy and then rulemaking procedures. On the next two slides, I've just got links to where you can find all of these CDE and state board procedures and policies that we just ran through. And that's about all I've got for today. Do you have any questions? I think that you're on mute, Board Madam Chair.
Thank you. Was on mute, I didn't do that. Could you talk to us about the consequences of failing to follow the Sunshine Act? Now you're
on mute.
You're on mute.
Thank you. So members of the public can bring lawsuits in district court to challenge whether boards followed the open meetings law or not. And if the challenge relates to whether the executive session was improper, the judge is going to review the recording of the executive session in camera, which means privately. And then if the judge thinks that a violation took place, the judge may order disclosure of that executive session recording. And then attorney fees are the other big sticking point. If you violate the OML, the statute requires an attorney fee award for the member of the public who had to bring the lawsuit.
And if a couple of us in the ladies' room have a discussion about an item that we're about to address and vote on, what's the consequence?
Well, it would depend on if someone found out about it, first of all. If they find out about it, and then if you do go into the meeting and vote on it, the formal action you take could be found invalid, and you'd have to do it over. So in that regard, it's sort of low stakes. It's just invalidating your action, and you have to do it over properly, but there'd probably be an attorney fee award tied to that as well.
Okay, thank you. Colleagues, do you have questions? I will go down the line. Board Member Sheffel, do you have any questions?
No questions, thank you.
Board Member McClellan.
None for me. Thank you, Madam Chair.
Sure. Board Member Escarziga.
No questions, thank you.
Board Member Durham.
Well, thank you, Madam Chair. I don't have a question. It really is ground that we've plowed before, but if you walk across the street from our building to the state capitol, you will find not a single legislator who even makes any attempt to obey this law. And frankly,
you're talking about the Sunshine Law, right? You're talking about the Sunshine Law?
Sunshine Law. And frankly, it's not due to an evil intent that they somehow wish to disregard the law. It's simply you can't do business. You can't, because the problem is you have to notice a meeting of the discussion. And so as has happened to me on hundreds or thousands of occasions, a legislator would come to me and say, would you accept an amendment X to your bill? Or I would ask them that same question. The fact that that's not noticed then creates the violation. And there's simply no way to do business in and comply with the law. And the law should have been changed a long time ago to understand that reality. And I'm sure that anybody who's spent any time over there fully understands that. And yet I'd be surprised in today's world if a citizen who found out about such conversation about amendment would have any luck in court challenging what the legislature had done or even making them vote over on it again. And it's that casual violation that I think creates the problem and the heartburn. And I think I think it was Disraeli who said, the best cure for a bad law is its strict enforcement. And I've always really agreed with that. So I think the practical side, I think there are two things that and one of my thinking has evolved on over the years, and that is how we deal with ex parte communication on quasi-judicial matters. I do think on that we have to be very strict, and frankly a lot more strict than I would have thought 6 years ago when I started as a member of the board. That's a whole different thing that we do that the legislature doesn't do. They don't engage in any quasi-judicial matters, so they're strictly legislative. So if you take that out of the equation, where I think we have to be quite cautious of the restrictions there, I think when it gets to the rest of the statute, I think it's impossible, particularly when we're back in person, it's really impossible to avoid violations. And I'll just say for me, for one, I think, a casual discussion of Rule X and whatever we're going to do in Rule X is not immoral, illegal, or unsavory, and doesn't and should not deter a board from having rational relationships with each other and being able to work through issues. Because if I run into Ms. Rankin before the meeting starts and ask her about X, I don't intend to violate the law. I doubt she does. But the fact is, the minute we mention, oh, we've got Rule X on the agenda and it's really a bad idea, technically we're in violation. And so I think common sense, it's one thing to get all 7 members of the board together and talk about a rule and with quite deliberate planning and all that. It's another thing to restrict our individual conversations about it, and I think we just need to be practical. And I would invite any member of the legislature who has a dissenting opinion to say so. I don't think you're going to find any, but I would more importantly encourage them to try and do some, try and let's create some statutes that really get at a problem rather than restrict what I would characterize as normal civil discourse. Thank you.
Mr. Relnick, you have your work cut out for you. You're going to be defending a lot of this. Could you just take one more minute and talk about ex parte? Because I'm not sure that you did talk about that. And that is, in fact, an area around which there's sometimes confusion, or at least for somebody new, there might be confusion. We try to be very careful about that. But
Sure.
we are often approached, in all honesty, by someone who doesn't perhaps understand that, or does understand it and is trying to trap us.
Yeah, that is a great question. And the board's own code of ethics has a section about ex parte communications that's definitely worth reviewing, especially before your next, say, charter appeal hearings or accountability hearings. And the whole idea behind that is that anytime you're sitting as a quasi-judicial entity, you're the decision maker, your decision should be solely based on the record before you and not based on any discussions you've had with either party outside of the hearing. So this could come up in different contexts. People might send you emails individually, or they might call you and try to lobby you or invite you to their school to visit. And it really is just important to not have those conversations with people, alone with those people outside of the official proceeding, because it gives them an opportunity to you know, it gives them an opportunity to taint the record and taint your decision. And it could be a basis potentially for your decision not being invalid if you're found to be impartial. It just makes you look impartial. So you shouldn't be having one-on-one conversations outside the presence of the other party. That's what ex parte actually means.
Thank you. I actually came across a situation where I was contacted and I told the individual that at this point I could not discuss it with him. And he became furious and contacted our office, and it took actually some help from the AG, this is a staff person at a school district, to convince him that I was not blowing him off, that I really could not have a discussion. However, my understanding is that if someone wants to share opinion or information with us, they are free to contact us through Angela, through the board office, to ensure that we all get the same information from that individual. Am I correct on that?
I think it might depend a little bit on the context. That's one where we might need to look at the procedures and see whether they allow for the public to submit comments. Is there a specific, would it be like an accountability matter or a charter appeal?
Well, for accountability matters, we actually, I believe, created an opportunity for citizens within a particular time period to send information in to the office, which would then share that with all of us, not with individual members. I don't know about other situations. Maybe you could.
I think, Madam Chair.
Yes, Mr. Durham.
I think as a matter of clarification, I think that if a member of the public wishes to submit something on a quasi-judicial matter to us, I believe that they can send it to Angela, but she needs to notify the council, both councils, and they have to sign off on whether or not it's something that I think both councils would have to sign off on, whether it's something they think we ought to see. I think where I've seen it the most is periodically I will ask staff for information that is publicly available, but I'm asking them to compile it for me for the purposes of the hearing. And at least in the past, I think what the staff has provided that information, our legal counsel has notified the parties that I have requested this information. They've had the opportunity to object, and when it's publicly available, at least up to this point, their objections have been noted, but I think not found to be meritorious. So I think when you're dealing with quasi-judicial matters, you haven't been asleep for the last 30 years and suddenly awakened to a fresh set of facts. We all have our backgrounds, what we read in the newspapers, all of that. So I think it's important, but it is important to note that if it's publicly available information and it's compiled, and sometimes I've compiled it on my own, I'm certainly free to do so. And if I want to share that with other members of the board, I'm certainly free to do that. Although I do think it's appropriate to notify the parties that this information has been either requested or compiled and shared.
Thank you, Board Member Durham. Counselor Julie?
Sure. I just, by way of context, I think Jenna's exactly right? It's very fact specific. Our guidance regarding ex parte communications is really designed to cover two different things. One is that you're literally being lobbied on behalf of one party and without the knowledge of the other, and that's its own problem. But the other thing we've got is a number of things you do you're really constrained to the record the parties are presenting. So sometimes the ex parte communication is about people wanting to send you information or make allegations or something like that that is outside that appellate record, right? And then there's the circumstance Mr. Durham's talking about where information that's either generally known or within the records of the department that we've just processed that with the parties. The fancy legal term for that, right, is judicial notice. And the main thing, though, is use the lens. Like, even though I wasn't around for Governor Polis's robe wearing, right, there the value in that, and I'm not suggesting you all get robes, is just to say, look, if a judge was about to hear a case and somebody came up to them and was saying, I want you to read this, or I want to talk to you, but whatever, I mean, to wear that mental sense of the robe, right? If you do that, my guess is you're going to get this issue right.
It does take a little bit of practice, though.
I'm not wearing a robe unless I get a powdered wig. I really need it. So I may get a robe just for that reason.
Mr. Ehrlich, did you have something else you wanted to add?
Oh, no, I just thought Mr. Durham's explanation was good because oftentimes those issues are resolved with a quick email to both parties' lawyer and we can just work it out easily.
Okay, that's helpful. So I wanted to bring that up because this is the issue that's most likely to come up soon enough for all of us. And if you've forgotten or if you are new, you might find it surprising. I know I did at first. I did not quite understand it. Board Member Esser, did you have some questions?
Thank you, Madam Chair. Jenna, thank you so much for that thorough report on what we can and can't do. I just want Julie to know that I do want a robe for ex parte, but thank you.
Sounds good.
Board Member Rankin.
Thank you, Madam Chair. This is a good time to say it. I appreciate a lot of the information that we continue to ask for is up on board docs. And so if this can be put up there and stay up there for reference, I think that's excellent. And Board Member Esser, you can have the robe. I want the wig.
Thank you. Any other comments or questions, colleagues? Thank you so much, Mr. Ehrlich, bringing us up to date. I believe that sometime later in the year, we probably will go back and look at our board procedures and just check and see if they are still complete and as we want them to be. But for right now, we decided we would allow our new members some time on the board before we go back and start looking at that and see what we might be missing or what is unnecessary at this point. So thank you very much. I'd like to suggest a roughly 15-minute break. If you would come back at 11, I would appreciate it very much. Thank you.
All right, Madam Chair, we are back live.
Thank you very much. The next item on our agenda is an informational presentation on the planned framework adjustments. Commissioner?
Yes, thank you, Madam Chair. We're bringing this forward as another item that has been impacted due to the COVID-19 pandemic. So we're bringing this item to you just for informational purposes right now. There's no vote required. And so I'm going to turn this over to Associate Commissioner Rhonda Hannaford.
Thank you. Thank you, Madam Chair Schroeder, Vice Chair Durham, and members of the board for the opportunity to share an information item on the school and district plan performance frameworks. And per the request of Madam Chair Schroeder, we bring you this information item. And I think Lisa's going to share our slide deck. There we go. And we're going to jump to slide 2. All right. Thank you. So today we will review the board's vote on the elementary and middle school performance framework changes that occurred prior to the COVID-19 pandemic. We will then review additional considerations for upcoming high school and district performance framework adjustments, followed by board discussion. So as a quick review, over the spring and fall of 2019, the state board members considered options for adjusting the elementary and middle school performance frameworks that they approved 2 options on October of 2019. The first option approved was incorporating an on-track growth indicator for CMAS in grades 3 through 8. The on-track growth indicator includes 2 areas. There's a catch-up and a keep-up. Catch-up included students not yet meeting grade level expectations are expected to advance to the next performance level within 2 years. Keep-up included students meeting or exceeding grade level expectations are expected to maintain grade level performance over a 3-year period. The second option approved was increasing the cut score required to earn a performance plan rating by 8 percentage points. And this would move the performance level cut point from 53% to 61%. Also included on this slide is an information link to the elementary and middle school performance frameworks and provides an overview of these adopted state board changes from this past November. So prior to COVID-19, the implementation timeline of the new elementary and middle school performance framework adjustments, including the on-track growth and cut scores, was to occur in fall of 2020 as an informational framework. So no points would be a part of the framework during that informational year. Then the official performance framework adjustments would be reflected in the fall of 2021 frameworks and would include points. And so although we are sharing with you the elementary and middle school performance framework adjustments, we also included some information here connected to the high school and district level framework adjustments the board may choose to consider in the future. So all of these timelines for the elementary and middle school performance frameworks, as well as the high school and the district level performance frameworks that the board may choose to consider in the future, have all been impacted by COVID-19. The 2020 accountability pause halted the release of frameworks in fall of 2020, which impacted the timeline for the information frameworks at the elementary and middle school levels. So because of the disruptions of COVID-19, this entire timeline is impacted and the department is needing your guidance. We definitely know that this is of interest to Madam Chair and other members of the board, and we thank you for that guidance. So the board, moving to the next slide, the board also asked us if there were other accountability flexibilities in addition to the elementary and middle school performance framework timelines, and there are, in connection specifically to the high school and district performance frameworks that are listed here. So the department began to share information with the state board about upcoming legislative changes for the high school and district performance frameworks last March of 2020. However, with the accountability pause, the discussions with the state board were also delayed. So while some data collections have begun as possible, none of the following have yet been incorporated into the performance frameworks. So the following bills here require adjustments to the high school and district performance frameworks. There's the addition of the military enlistment, and that began in the 2018-2019 school year. Then we have the addition of advanced placement, concurrent enrollment, and international baccalaureate for non-English language arts and math subjects. And that is set to begin this school year in 2020-21. Then there is the addition of higher achievement level for college and career readiness. Those are the CCR demonstration options. Those are also set to begin this school year. And last, we have the adoption of a high school on-track growth metric, which is to be determined by the state board. So there are several ways we could address these with your direction. And as we have contemplated options, a lot of those options depend on what happens with state assessments and state accountability in 2021. And at this point, that is just not yet known. So there are many variables. Moving to the next slide. So with all of that in mind, there are, though, a few possible next steps for the board's consideration. First is at a future board meeting, the board may choose to vote to adjust the elementary and middle school framework timelines to address the impact of COVID-19. An additional option is that the board may continue to monitor the impacts of COVID-19 to determine if other adjustments may also need to be made. Okay, we'll go to the next slide. So really, we're going to open it up for discussion. We really appreciate the opportunity to share this information item with you. And joining me today is Lisa Medler. She's the Executive Director of Accountability and Continuous Improvement. Anne Marie Hutchton, she is the Accountability Analytics Supervisor. Both Lisa and Marie have been amazing, and they've been the two leads in this area. And at this time, we're going to just welcome discussion and questions that you might have.
Thank you. Colleagues, we'll go ahead and go down the line, and let me start with Board Member Rankin. Do you have questions, comments?
No, not at this time, thank you.
Board Member Scheffel?
Yeah, I'm just trying to digest it also. I'm not really, I have to think about what would be the best approach. I appreciate the presentation. It's very helpful to give context, but I'm not quite there yet.
So the first part about the elementary and middle school, the changes in the way we calculate is basically the reality that we didn't have an assessment last year. And so we're off the year, and this just recognizes that when we passed that particular rule, that we needed to change the dates. The other items, of course, are a little more complex because they were areas that we were to go into,
right?
The high school, the graduation, etc., and we did not. And I don't know that. I mean, I think it's up to us to decide whether we want to start that conversation or we want to wait. The high school assessments, if I understand correctly, will be given. So that's also a sort of a different situation in terms of what should we be doing in terms of moving forward.
And I think the dates make total sense. The other areas, I guess, are the question. What do we do? Pause, go forward. We have to kind of think about implications. I don't know what district superintendents are saying. I know the other constituents saying the importance of continuing to test and hold folks accountable, and yet we have such challenges. So we have to really think about implications.
Right. Okay. Board Member McClellan.
Thank you, Madam Chair. I'm kind of in the same space, sort of absorbing this and trying to absorb this in the context of knowing that we have missing data and really not sure exactly what it's going to look like with respect to COVID as we go into the spring. So, still absorbing. Thanks.
Board Member Esser.
Thank you, Madam Chair. I don't have any questions right now. I'm in the same space. I think we need to watch school safety and health as we look at this.
Okay. Board Member Escarzica.
Thank you, Madam Chair. I think I have just a couple questions, and one is that I see that the statute is listed on several of these, correct? So I'm looking at the upcoming high school and district performance frameworks. So we would need adjustments to statute to delay some of these deadlines, or under statute, it allowed the board to set the timelines and we have that kind of flexibility.
Ms. Hannaford, can you answer that?
Statute questions are always great to have, and it's always good to have my partner Julie Tolleson here, who she might be able to address that if it's required through a statute or a board rule change. I do know that it is the board that sets the timeline for the implementation of the frameworks, but that is also guided by the statutes beginning at these set times. And then we're also up against, if we have accountability or don't have accountability in 2021 is just unknown. And a lot of this might just come right alongside with what happens with state accountability in 2021. And if the decision is made that there is not state accountability, a lot of these timelines, it's impossible to implement them because we don't have the accountability there.
Right.
What is the timeline, Madam Chair, for trying to figure this out? Are we, this kind of information item, do we need to come up with a plan by next month or?
Well, my thought was that when we passed the rule regarding the changes at the elementary and middle level, we sought to assure districts that the first year that the new measures would be implemented would be a year in which it would not count, right? That it would just be for information only. And I just want to retain the assurances that once we get to that, that's how we start this process of making the change. So it seemed to me that going ahead and moving it by 1 year, as we did a number of other items, would make sense. We could just hold off and do nothing, not knowing when assessments will be held for accountability purposes. I mean, we have that option, but I didn't want folks to be worried that we would implement that change without the 1 year opportunity for districts to see where do they fall under the new rules. At the same time, where did they fall under the old rules? Because it was a change for some districts, it was not a change for other districts, et cetera. And I think it was a little confusing for them to whether they went through and did the calculation or did not do the calculation. So I'm just trying to give some assurances that we will hold true to that part of our rules.
Okay, and I think thank you, Madam Chair. I think the only other thing is I'm looking at adoption of high school on-track growth metric, and I look forward to talking with staff and Marie and others, even if we do have the high school assessments given this year. The impact of the pandemic on test data, if you're using that as your baseline, messes things up terribly. And I'm sure, Marie, this is their, this is my degree too, but this is their life and they'll be thinking about it. So I'm going to be interested to see their methodologies, and it's a lot for them to do, and they're going to need time to work through this. And so, yeah, I just wanted to make that comment. So thank you.
Sure. Board Member Durham.
Thank you, Madam Chair. I think when we originally established these changes, we essentially had a process, and the first year was what I would characterize as a phase-in year, so that people would see the impact of what we're doing. I think it makes, since we have no data from which to draw any conclusions from this last year, maybe to move those, to extend, to have the transition year, the year after we have some data. And I do have a question for Dr. Francis. I'm not sure it's quite on point, but it might be a good time to, if I could, Madam Chair.
Yes.
Dr. Francis, did the department recently release some graduation rates or some commentary about graduation rates? And if so, what were those? And did I miss the email? Possible.
Yes, Vice Chairman Durham, we did release that, and that was essentially from data from last year. I believe, let's see, Deputy Commissioner Pearson, are you on with us? I'm not sure if that went out to the board members first, or.
I believe the news release went out to everybody Tuesday. The grad rates were up slightly from the 2019 graduation class of 2019. We were up about 0.8% overall. Our dropout rates dropped a teeny bit as well. And we've got lots of the disaggregated data. We saw some actual gains for some of our students that we've been struggling with historically to have higher graduation rates. I do not know that if that went to you beforehand. I'm very sorry. We'll make sure we get that in the routine to go to you all first before we send it out.
That's fine. I don't, that wasn't why I raised the question. I was just curious what the numbers were. And do we have confidence in those graduation rate numbers, given the fact that schools were essentially closed from March until the end of the school year? And what if we do anything do we need to do in terms of additional verification of that data, or did the districts just essentially pass out diplomas? I guess the question I have.
And those are good questions, and all questions that we had been asking as well. We followed up with some districts to check in just to see, and we had also worked with our districts pretty closely last spring to see if there was any adjustments or any concerns they were having about graduating students. I think stepping back and looking at it, we were in mid-March. By mid-March of a student's senior year, they're pretty much, it's already decided whether, they've got their credits met or they don't, or they're very, on track to finishing things up in that last 6 weeks or so of school. So I don't think we don't feel like last year that the spring disruption made much of an impact at all on graduation rates. What we're looking towards is what might happen this school year, and that's what we're trying to talk to districts about and support them and figure out where to go from there.
Okay, thank you. Appreciate it. And that's, I have no other questions, Madam Chair.
So I brought this up because for a couple of reasons. One, I wanted to make sure that we are still going to hold true to that for the elementary and middle, for that, I want to call it practice year, but that's not the right, I forgot what the term was. No matter when we actually can begin this, that the first year is one where it doesn't actually count in the calculation. If we're still true to that, I don't know that we need to make the change now, or whether we should wait until we know that we have a system of assessment so that we can move forward with determining that, as long as we're sure of that. The other question that I have has been brought up by staff, that we have this other job, which is to look at the high school information. Do we want to start working on that now, or do we want to wait a while until, again, there's more stability in our data? So I'm asking colleagues what your thoughts are, and I guess Commissioner can tell us whether she thinks we should get going on this right now, because we're holding off on a lot of work.
Yeah, thank you, Madam Chair. I'll chime in, and Marie and Lisa and Rhonda, if you want to chime in too. I do think we might want to hold off just a little bit before we start the high school data. We really, I think, are going to need to get some data and see how many people are taking the test, see what the results are. Or else I'm afraid we're going to do a lot of work, and then it won't be relevant. So I think we might at least need to wait until we see how this year goes. Will the state assessments be given? How many people are taking them? Those sorts of things. And then we would have some real data to do some mock-ups of and do some analysis of. I'm afraid we might be doing it in a vacuum if we start right now.
Okay. There is the expectation that the high school students will be taking the assessment. I thought that the stakeholder group specified that, and I had not heard anything to the contrary. Commissioner?
I believe so. And Ms. Hannaford is going to talk about that at the very next session. But of course, so that is what the stakeholder group recommended. But of course, it's all still dependent on, you know, our schools in session, who's taking these, those sorts of things. So there's still some variables that we need to see how they play out, but the stakeholder recommended we give them.
Okay, thank you. Mr. Durham, did you have your hand up?
Yes, ma'am. Thank you. I think I do agree with Dr. Anthus that until we have some data, trying to guess at whether or not there should be revisions or changes in policy really will not make a lot of sense. That and we may, I'm going to guess kids are, children are very likely to want to take, if at all possible, to take these college-related exams sometime this spring. And that may be the start of us having enough data to trickle in so that we have some idea of where we're headed. But until we have some, I think, a lot more available information, that the delaying the implementation of the changes for another year make perfect sense, and maintaining the transition year still makes sense. And then we'll have to work from there based on data as we get it.
All agreed, colleagues? So Commissioner, I'll leave it up to you and staff to determine when you think we should start working on this. You might recall it took us a really long time.
Yep.
We struggled with it, partly because some of it was hard to understand, frankly. And also because we just really had to think through the consequences of any changes that we were making.
Absolutely. We'll put some ideas on paper, but even our ideas are a little tentative right now based on how this year progresses.
Okay, great. Thank you. Thank you, Mrs. Hanford. Appreciate it. All right, colleagues. Next item, policy implications from the stakeholder group. Oh, and it looks like you're still here, Ms. Hanford, so proceed, please.
Thank you, Madam Chair. And members of the board, thank you for the opportunity to provide an information item from the COVID-19 Policy Implication Stakeholder Group recommendations. Joining me today in our presentation is Ms. Lisa Medler, Executive Director of Accountability and Continuous Improvement. And she is going to help advance the slides.
Rhonda, you want to keep going? I'm having trouble pulling up. I have it, but it's not letting me upload it. So just keep going, okay, and I'll work on it.
Yeah, that sounds great. Thank you. So today we will provide a brief background on the stakeholder group, including its membership. We'll review the impact of COVID-19 and the resulting disruption of the 2019-2020 school year that the stakeholders discussed, followed by the stakeholders' recommendation topics that reached consensus and those that did not reach consensus. We'll review which of the recommendations require legislative action and/or state board rule change, and we have an opportunity to further explore one of the recommendations within the accountability improvement planning topic. And then we'll conclude with board discussion. So in the 2020 legislative session, the Colorado General Assembly included in the School Finance Act the creation of a stakeholder group to address issues for students, schools, and districts presented by the COVID-19 crisis. The commissioner convened the COVID-19 Policy Implication Stakeholder Group, which worked from August through November of 2020 to understand, discuss, and make recommendations to policymakers. The purpose of the stakeholder group was to review the impact of the COVID-19 pandemic and then the resulting disruption of the 2019-20 school year, and to make recommendations regarding whether and how to proceed with state assessments, accountability, accreditation, and educator evaluations during the 2020-21 school year. So through an application process, 19 stakeholders were selected, representing a variety of perspectives from all different parts of the state, which definitely ensured for robust and thoughtful discussion. Members were also selected to represent diverse viewpoints about assessments, accountability, and educator effectiveness by including individuals impacted by these systems, individuals with expertise in these systems, and individuals engaged in advocacy around these systems. Members of the stakeholder group, they worked very hard to find common ground so as to make consensus recommendations. And these recommendations were made definitely in a world that continues to change each week. And of course, it is impossible to know what spring of 2021 will look like. The stakeholders acknowledged that it is difficult to make static decisions in a quickly changing world. And the Colorado Department of Education, we sincerely thank all of the stakeholders for their hard work and their commitment to this process. They engaged in a lot of thoughtful dialogue and discussed their perspectives in a very collaborative manner. Okay, and we're going to move to slide 5. The stakeholder group began with a review of the COVID-19 pandemic impact and the resulting disruption of the 2019-20 school year, including the student transition to remote learning and the cancellation of the state assessments, accountability, accreditation, and educator evaluation systems for the 2019-20 school year. During the spring of 2020, as I think we probably all recall, Colorado was in a stay-at-home executive order, which resulted in schools transitioning to remote learning. The stakeholders discussed how schools and districts had to address many student, staff, and parent needs during this transition, which have persisted into this fall and into the winter. Specifically, the stakeholders discussed, but not limited to, schools creating remote environments, hybrid, in-person learning environments. They discussed how schools were working very hard to prioritize health and safety protocols, training teachers to teach remotely, while also working with families to provide Wi-Fi and devices, all while finding creative ways to build relationships with students and families in this remote learning environment. The stakeholders also discussed that in 2020, state assessments were canceled through executive order, and then no new state accountability school and district ratings were issued in 2021 as a result of the state accountability pause. This meant that the school and district plan types rolled over from 2019 to 2020. And then the stakeholders discussed how the disruption to learning in the spring of 2020 impacted the education effectiveness system. The cancellation of the 2020 state assessments, the disruption to local assessment systems, and the resulting lack of school and district performance frameworks meant that many educators had insufficient or incomplete data needed to produce a final evaluation rating that is based 50% on measures of student learning and outcomes. So as a result, prior to the start of the school year, CDE announced the department would not be monitoring the student learning outcomes portion of the educator effectiveness requirements for educator evaluations in the 2020-21 evaluation cycle. Okay, we'll go to the next slide. So I'll begin with sharing the topics where the stakeholder group reached consensus and whether or not the recommendation would require a statute change and or a state board rule change. So within the state assessment topics, the stakeholders recommended not to administer either the CMAS, social studies, or science assessments in 2021. It's important to note that the science assessment would require a federal waiver to not administer. The stakeholders also recommended administering the PSAT, SAT, and the Colorado SAT essay option. And they reached consensus to provide PSAT, SAT, individual reports for achievement and growth to students, guardians, schools, and districts. Moving to slide 7. Within the accountability and accreditation topics, the stakeholders reached consensus in several areas. One, they agreed to pause the calculation and publication of school and district performance frameworks in 2021-22. Thus, the school or district's ratings would roll over from 2020. They also recommended that for the 2021-22 year, special considerations be used for schools and districts on the clock, such as opening the request to reconsider process. Second, while the stakeholder group recommended rolling over plan types from 2019, It further recommended that districts continue to be responsible for the reporting and implementation of other legal responsibilities of district accreditation, things such as safety, finance, and accreditation contract assurances. And third, the stakeholder group recommended providing an optional spring 2021 submission window for improvement plans. And those are the Unified Improvement Plan, the UIP. The process should also be adjusted to better reflect the learnings and needs of schools and districts as a result of the impact of COVID-19. So later in the presentation, Lisa Miller will share more about the board's exact authority over the UIP optional spring 2021 submission. Okay, going to slide 8. And the last topic the stakeholders reached consensus on was in educator effectiveness. Because of the cancellation of state assessments and school disruptions due to COVID-19 in the spring of 2020, the stakeholders reached consensus to base educators' final evaluation ratings 100% on their professional practice score for the 2020-21 school year only. Now we'll move into slide 9, and we'll look at the topics that the stakeholders did not reach consensus. And we'll begin with CMAS, English Language Arts, and CMAS Math. So the stakeholders, they did not reach consensus on either one of these assessments for a range of reasons, including but not limited to stakeholders that were in favor of administering assessments expressed a desire to measure student learning loss, provide families and educators student academic information, and provide an opportunity for the Colorado community to see student learning progress across the state. Stakeholders not in favor of administering assessments expressed concerns over loss of instructional time to administer CMAS, the perceived value and credibility of the assessments, and the misinterpretation of student results in the context of COVID-19. Going to slide 10. The second and final topic the stakeholders did not reach consensus on was the public release of CMAS and PSAT, SAT results, again for a range of reasons, and these are some of them. Stakeholders in favor of public release expressed the need to provide public results as another data point to show student learning, provide an opportunity to see student progress across the state, and understand student learning loss to make better policy and resource decisions in response to the impact of the pandemic. Stakeholders not in favor of public release expressed concerns about the potential inequities to access the assessment and corresponding credibility issues, and misinterpretation of student results within the context of COVID-19. So going to slide 11. The stakeholders' recommendations and findings are accessible in detail on the stakeholder group's webpage and have been provided to the Commissioner of Education, Dr. Katie Anthus, state legislators, and the governor's office. As noted on the slides, many recommendations require legislative changes, and then a few would also need state board rule changes. However, one requires only a state board rule change, which is the recommendation to provide an optional spring 2021 submission window for the UIPs. So I'm going to turn it over to my colleague Lisa Medler to pick it up from here and go into more detail on that one.
Ms. Hannaford, can I, Madam Chair, that was a lot of information. I wonder if we should pause there for a minute before we move on to the more detail on the UIP.
That sounds fine, Commissioner. Colleagues, let me go down the line and see if you have some questions or comments at this point. Board Member Rankin.
Sorry, Madam Chair, I was looking at the handout and I was a little lax in getting back to the pictures. I guess one of my main questions is the next presentation, so I think I'll just wait in here for that. I believe the stakeholder report that I read and what they say aligns perfectly with the phone calls I've gotten. So I think they did a good job expressing what the people seem to express. So that part I thought was good. But there's some real challenges here, and it's going to be interesting to see what happens.
Thank you. Board Member McClellan?
No comments yet. Thank you.
Board Member Esser?
It's a very very difficult situation on all sides, and I can see how the stakeholder groups could not come to consensus. But considering the laws and the requirements around whether or not we test, I don't think there's anything we can do at this point until we know what the feds are going to do and what our own legislature is going to do, which doesn't mean I don't have comments about whether or not you should give a standardized test in the middle of a pandemic. I would like to say that as well. So that's what I have so far. Thank you, Madam Chair.
Sure. And we don't really know what the next 3 months are going to offer for our kids. I think we ought to be open to waiting and then maybe having a very clear position one way or the other by that point. Board Member Durham?
Thank you, Madam Chair. I don't think only that at some point in time we have to at least make a decision to plan for something this spring. And I believe we should probably plan for existing law. And should the law change, then we could reconsider our options. But I don't think we should plan at this point in time based on what we believe a change might or might not be. So I think staff does need to plan for the administration of the standardized tests this spring, as that is still federal law, and I believe it's still state law. And, so we need to plan as if that's going to be the law. It's not in our power to change it, and if it does not change, and even if it does, we may elect to proceed anyway. If the requirement goes, we may elect to do it on an optional basis. So, but I think I would encourage Dr. Anthus and her staff to move forward so that if that is the situation when we get to May, that we're prepared to deal with it.
Thank you. Board Member Escarzaga?
Thank you, Madam Chair. So I'm going to echo the comments made by Dr. Esser. First, I would say that for this committee report, I very much appreciate this presentation. I had the opportunity to sit in on every meeting. I watched them all live. I went back and did every single breakout group, and I truly believe that this report reflects the hours and hours of work that was put in there. So I want to say thank you. And I think as far as the planning piece, it's kind of dicey. I mean, I think schools, if we were going to end up not requiring assessments one way or another because the feds or the state, they would like to know that sooner rather than later, because they are already planning and starting to train teachers and working. They have no choice, right? This is the direction the department's given them. I think the sooner they know for sure, the better. The longer it gets dragged out, the more anxiety, the more phone calls and everything else you're going to get, and the more wasted time potentially. If we do all this planning and other states are all getting waivers and Colorado's the only one, I mean, obviously we may join in, et cetera. It's hard. It is hard. And unfortunately, having someone who's done this, like I administered and oversaw assessments for 40,000 kids for over a decade, the planning and the work that is going to go into this unnecessarily, particularly if we don't give them, I'm not sure we can stop that train, but it is what it is. So anyway, thank you for this presentation, and I look forward to further discussion.
Thank you. Board Member McClellan, did you have your hand up?
I did, Madam Chair. Thank you very much. I just wanted to touch on a little bit of the feedback we got from some of the group on a couple of points where consensus was not reached. With respect to public release, I think all of Colorado is kind of holding our collective breath to determine where do we stand in terms of learning loss. I don't think there's any stakeholder anywhere in this discussion who doesn't care desperately about finding out where we are in terms of learning loss so that we know what we need to do about it. I've always been of the opinion that assessment data is best utilized when it's helping us figure out where we can lend a hand and help bring improvement along. This is one of those moments where we don't know where we are. So as soon as it is safe, my hope is that we do get some data so that we can figure out where we stand. And I'm having a little bit of trouble figuring out how we could possibly justify keeping that data or that transparency out of the hands of stakeholders, including parents. Parents want to know where their child stands. Parents want to know where their child's school stands. Parents want to know where their child's school district stands. And they have a right to know. And we are in a moment where we don't know. So my hope is that to the extent that it is safe, that we can get a handle on how bad the learning loss may be. I do hope we have a very relaxed attitude about how that is used with respect to things like educator effectiveness, because of course we want to be sensitive to the fact that teachers are not at fault for the fact that we have a raging pandemic. So to the extent that it is safe and possible, I hope we're able to get a clear picture of where we are, and I hope that we're able to be transparent in sharing that with stakeholders who care very much about where the help is needed, so we can come together and make that happen. Thanks, Madam Chair.
Thank you. Board Member Escarzaga, I see your hand up, but let me allow Board Member Scheffel her first turn, and then I'll get back to you. Thank you.
Yeah, I would just say thanks for the presentation. It's very helpful. It'll help inform our thinking going forward. I do think we're in a waiting period, but I think some of this feedback is very helpful to our work going forward. So thank you.
Thank you. Board Member Escarzaga. You're mute, you're mute, you're mute.
First time, but I'm good with that. So I thought we were just going to ask questions about the presentation, but if we're going to make statements about some of the information, I do feel compelled to talk about this concept of we don't know where our students are. And I think back and I say, this is what I've been telling folks, that we have decades of NAEP data. We have decades of NAEP data. We have years of state assessment data that tell us where our students are, where our schools, where our districts have been, with very little change year to year. And so that, and then the other one is my question, or the other part I hear a lot of people say is, well, we won't know where to drive resources. We won't know where to focus. And again, I'm going to go back to the years and years of data that we do have and ask the question, what would you do differently? What would you do differently if we're 3 months behind, 4 months behind, or 5 months behind? So just food for thought. A couple other things, this idea, like if I went to my student's school, which I often would, and I asked my teacher, where's my student? Where is my daughter in reading right now? Where is my daughter in math? They tell me. I would expect that every student, every parent should be able to ask that and can get that information. And to any school who says we don't have it to give, I would be very surprised. And I don't care what school model you're using. So I'm just hearing a lot from stakeholders, parents. Have a lot more parents than I ever have seen saying, how do I opt out? Where on Denver do I opt out? I said, I don't know, don't ask me. And I'm just worried. I'm just worried that we we need to be very thoughtful about this conversation and listen to the many and not the few. So with that, thank you.
Thank you. Commissioner, did we ascertain that we have flexibility as to when the assessment is given, that rather than March, early April, that we could in fact move it to May, so that we really have the full year of whatever was learned?
Thank you, Madam Chair. Yes, Ms. Zarkowski might be on with us too, so I'll let her chime in. We do have some flexibility, but remember that districts all shut down for the year at different times. And so sometimes they're already shutting down in May. But yes, we can extend the windows, and really all of those options are on the table still. Okay. And including moving it into May for some districts that would work for. But there are always these logistical challenges we have to keep in mind, not that we can't adjust them, but that we keep in mind when we're doing sort of large scale state assessment.
Okay. Please keep us informed about that. I recognize that there are folks who would like some kind of certainty about what's going to happen. And all I can say is I'm really sorry. There's no certainty that I'm going to the grocery store tomorrow and I get COVID and I'm dead in 2 weeks. So this is a very different environment and we cannot provide certainty. I don't know how much preparation to address Ms. Escargos' comment our schools actually need in order to give the assessment, but let's figure out a way to make that not super complex, because it will not be used for our performance frameworks. It will not be used for educator evaluation. So it seems to me that some of those concerns will not come into play. But I do agree that to the extent that we can do this, we can give some assessments, that we should seriously consider doing that. I just don't think this is the time to be making that decision, personally. Any other comments? Board Member Esser.
Thank you, Madam Chair. I just wanted to address the logistics of giving these standardized tests, having given them since before No Child Left Behind. Colorado started this in 1999 with the standardized tests. I have proctored everything from CSAP to PARC to CMAS. It takes weeks to get ready for a school district to give standardized tests. Also, we have, at least in the districts that are in my congressional district, they have some of the schools, about 25% that are at home only. So those tests will not be given unless the kids come into the school. That requires even more planning and more logistics. So those things we need to keep in mind. We also need to keep in mind that school districts have an amazing amount of planning in May for graduation and other transitions that are happening. So that would be very difficult the later in the school year we get to try to give these assessments. So it's extremely complicated. And I hope we keep that in mind as we go forward. So thank you, Madam Chair.
Thank you. Anything else, colleagues? Okay. It is approximately noon.
Actually, Madam Chair, we still have a little part of the presentation to go. We just wanted to, there was so much information, we wanted to pause questions.
My short-term memory is really on the outs today.
Yes, so I'll turn it back to Ms. Hannaford, yes.
Thank you, Madam Chair. And I'm actually going to turn it back over to Lisa Medler, who's going to go into some more details connected to the one of the recommendations of the optional submission of the UIP for 2021, April 2021.
So thank you, Dr. Hannaford, and Madam Chair and members of the board. Thanks for letting me present. I'm not going to actually share my screen again because it's I'm really apologizing. It keeps glitching and not letting me do it. So we're talking about, I'm going to just tell you which slides. I really apologize. So I'm on slide 12. I can try again because I know it'll be easier if I can show you. It's just
Ms. Nedler, how about we have Angela Maramba share her screen?
That's great.
So
That would be
Angela,
really
can
helpful.
you do that?
Yeah, so on slide 12 of the same presentation. So I'll go ahead and get started. If you're able to, yep. So on slide 12, so again, this is based on the stakeholder group's recommendation. And given the timeline around improvement planning, we figured it would be worth getting in front of you now, because this is the one area to remind you where you can move forward. It doesn't require statutory change to alter the dates on the timeline. That is up to the state board. This slide should look familiar. You have looked at it a few times over the past year to provide flexibility. It's gotten a little bit complicated as we've been transitioning. So it's been helpful to keep coming back to this particular slide. So let me just orient you a little bit. That blue arrow is the timeline that we've been using for the last decade. That orange line is really about this particular year. You had granted flexibility to schools and districts to not submit last April. If they chose to take that flexibility, then they were expected to submit in October, which they did. About a third of districts took you up on that flexibility. For today's conversation and based on what the stakeholder group was recommending, we're really talking about that April timeline again, just for this particular year. That green line at the bottom is referencing, just to remind you, we're transitioning to having October be the permanent timeline when schools and districts submit their plans. So it is a little bit sooner than it has been in the past. But I wanted to just make sure that you were oriented to all these different years and timelines, and point out that what I'm referencing now is this upcoming April 15th deadline. So if we move on to the next slide. And there we did add this as a new slide yesterday, I think really just to make it more concrete for you on what some potential next steps are. So that first option is to make the UIP submission window in the spring, that April timeline, optional. We would adjust the board rule. The same is true for the next option, where you can alter the deadline within this current year. Rather than make it optional, you're just moving the date to like later in the school year. And then finally, as you always have, you have the option of not actually responding to that recommendation and leaving the current rules in place. So just to lay those out a little bit more concretely for you. The final slide that I just want to cover, we was in alignment with the stakeholder group's recommendation on that optional board rule. So if we move on to the next slide, we do have some language that we drafted for you. So if you were interested in moving forward on this, we could come back at a future board meeting to adjust the rules. So this is not by any means asking for a vote. It's just putting something out that's a little bit more concrete. And so you'll see that we adjusted that April 15th to October 15th, so that essentially it's putting it into that next submission window next school year. So in essence, that portion of schools and districts would not be submitting an improvement plan this particular school year. We did tease out that districts would still be expected to submit the READ Act requirements. Those are the new ones that went into effect more recently, where districts are submitting for every school their the assessment that they're using and the program, the READ Act programming that is in effect in each school. So that would be teased out. Districts would submit that. We've already gotten a portion of those submitted since some districts had to submit in October already. So we would just expect the remainder of districts to submit still in April. So we just did tease that out separately. So we've got the district piece and then the school piece below that. So again, these were just things that we took the liberty of drafting for you so you could have something concrete in front of you to help you provide guidance on what you'd like us to do next on this portion. So with that, I think we can probably stop sharing the screen. And I will open it up to you if you have questions.
Well, I'm confused. Let's see, maybe somebody else can explain it to me. Board Member Shuffle, can you explain to me what we're doing? I'm just.
So I think what we're trying to do, right, Lisa, is trying to figure out how to adjust the timeline on the UIP so that districts have more time and more information to write something up that really can guide practice that makes more sense. Is that like the centerpiece of this?
Yeah.
So that
and the districts have already asked for that, right?
Yeah, I thought we already did that.
Madam Chair, can I chime in?
Yeah.
And this was sort of the hesitation because we know this timeline piece has been somewhat confusing. I think it's more hats off to you that you've been willing to provide this ongoing flexibility to districts. So you provided that flexibility last April. Only a portion of districts took you up on it. Now we have a whole nother set of districts that are still submitting in April. So it's essentially you're providing that same flexibility for the ones that haven't taken it yet. But we're just teasing out that the READ Act requirements that went into effect this year probably still need to be reported on. So that's the difference.
Are we talking about the READ Act or are we talking about the whole improvement plan? This is where I'm getting off track.
Madam.
Yeah, Lisa, go ahead.
Yeah, Madam Chair, we're talking about the UIP timeline, but as a reminder, and I know this is where the improvement planning process, remember, it brings in a lot of different requirements from many different programs. And one of the new ones that was passed just a couple years ago was related to the READ Act, and it's expected reporting through the improvement planning process. So I went very general to very specific because I know that's something that's been on your radar. To tease out that we would probably need to still recommend that portion still be reported, but that we're still in alignment with the stakeholder group trying to provide that flexibility so districts could choose if they wanted to not submit this April, and it would just be applicable to this year. So it really is about the improvement plan.
Can I ask a follow-up question, Madam Chair?
Please.
Okay, so Lisa, are you saying that you're suggesting, or the language you've drafted suggests that they would report on the READ Act compliance in April, which is not a change of date, but the UIP deadline would be extended for districts that didn't take advantage of it initially, so that we're all on the same page on the UIP. Is that right?
Madam Chair, yeah, yes, that is a much more efficient summary.
Thank you. I think we got it.
Okay. I'm doing better. Board Member Rankin.
Yes, Madam Chair, that was confusing and Board Member Shuffle cleared it right up. But I appreciate that the READ Act, of course, was teased out, because the sooner that gets in the forefront, the sooner people are going to remember what it stands for. So thank you.
Board Member Escarzago, any questions, comments?
No, thank you, Madam Chair.
Board Member McClellan.
Thank you, Madam Chair. I know Dr. Shuffle kind of offered some clarity, but I'm going to dial back and make sure that I'm understanding fully. Am I correct that some of these UIPs are already coming in and that this is our first glance to give us an idea as to whether or not schools or districts are in compliance with respect to the curriculum they're using and whether or not it is allowed under the READ Act? Am I understanding that correctly?
Madam Chair, The improvement plan. So yes, you are correct in your understanding that that we have received a portion of the improvement plans already this year. Again, because of that flexibility that you provided last year, is about a third of districts. At that time, they started reporting on that new READ Act requirement around the READ Act programming. The remainder of districts have not submitted and were not slated to do it until April. So if you were to grant some of this flexibility, then they would have until October of next year to turn in their UIP, but we would still ask them to report on the READ Act requirements that are new in April. So that would stand still. Does that help?
I think so, as long as I can be certain that that also requires them to report on which curriculum they are utilizing, so that we can make sure that we have a handle on whether or not we have a little compliance problem or a huge compliance problem when it comes to curriculum being used that is not compliant with the READ Act. Because I have had stakeholders come forward to me to share that that they are hearing that some districts may be under the impression or may be asserting that if they do not use READ Act dollars directly for the purchase of their curriculum, that it means somehow they don't have to comply with the READ Act, which is not correct. But it's important that we get that data very timely so that we know whether or not we have a really big problem or whether or not we have one or two districts, or maybe, knock on wood, wouldn't it be great if everybody was in compliance and following the law? But I just want to make sure that I'm not necessarily opposed to applying some measure of flexibility as is needed this year, but with respect to that one wrinkle, I would hope that we can get that data timely for good reason. Thank you so much.
May I ask a follow-up question, Madam Chair, to Board Member McClellan's comment?
Go right ahead, Board Member Sheff.
So Lisa, here's, I think, what Board Member McClellan's referring to, and I've had similar calls. I think there's some concern or confusion in the field that there doesn't have to be alignment in terms of early literacy curricula between the READ Act, things purchased with READ Act funds and things not purchased with READ Act funds. So I think we need clarity to the district superintendents, maybe to ourselves, and that's where the synergy between the UIP and the READ Act reporting could help, in the sense that what does the UIP say in terms of how they're teaching reading and compliance with scientifically based research, which is required by the READ Act, but also generally asks for alignment across curricula, not just with materials purchased with READ Act funds. So that would be the only glitch in separating the timeline there. There may not be an opportunity to look for alignment and consistency, so then you end up disadvantaging the READ Act piece anyway. So you might comment on that. And I think district superintendents are confused about it.
Madam Chair, this is something that I'm going to ask to do some follow-up. While I am representing accountability and improvement planning, and certainly we are working very closely with the READ Act team, I don't want to wade into things that I may mislead on. So if this is okay, if I can do some follow-up with them and then do some follow-up with the board, that I would appreciate that.
And Ms. Medler, can you speak just a little bit to the dates again? So if we move it to October, the submission, the rest of the submission, because we already have some submissions, the rest of the submission for October of the 2021-2022 school year, what is that covering? Like their UIP will be covering the previous year or both years? Just talk a little bit about that timeline. I just want to make sure the years are correct.
Sure. Madam Chair.
Yes.
The next year is when the new timeline goes into effect. So the vast majority of districts will submit for schools and districts in October. It will cover all requirements at that time. It will focus on the 21-22 school year and the 22-23 school year. So what we've done by moving up that timeline from, typically what was April to October, is now districts and schools, and this is why they were in favor of this, they are able to turn in a plan that is solely future facing for that particular school year and the following school year, rather than in the past, it was retroactive for that, you know, what a school year that's essentially past and the one in the future. It wasn't lining up logically. So just so you're clear, that is part of that transition to the new timeline.
Yeah, so that's what I'm trying to understand. Just the very basic thing. What's the purpose of the plan? And the purpose of the plan, even though it's already October 15th and you've been in school for 2 months, nevertheless, it's the plan that's based on analysis of your historical data. And what is your plan now to move forward in order to engage in continuous improvement? And that makes more sense than doing it in April because you were going backwards, or because you didn't have the data as yet in April to really thoughtfully plan out the future year, or both maybe. I'm not sure.
Yeah, so Madam Chair, I think your question's a good one. So I think what was not as logical to the field is that they were being asked to report on activities that had already happened that school year. And so it just felt like it was focused on compliance and not truly about planning. With this shift that you approved to the October submission, now they're looking at, it places the emphasis more on their local data, and then when state data is available, then pulling that in so that they can look forward facing and it's all lining up so that they're getting their planning done and they're starting the year with an implementing that plan rather than looking backward.
Right, and is this going to continue forward? Are we going to be on October 15 forevermore, other than some of the compliance with the READ Act, which we're doing sooner because why?
So, Madam Chair, you saw me do this. My hope for
get to the basics here.
I know this is very good questions because this is very complex. The hope for the plan is yes, certainly we could not have anticipated COVID, and I think that's what's made this so much more complex because we've been dealing with flexibility around COVID, and then trying to move into this new timeline. So so we'll tease that out. But assuming everything, then, we're able to move back into a routine. Yes, the plan is that is the permanent timeline, and it will make more sense for the field. To then answer the second part of your question about why are we continuing to focus on ensuring that the READ Act reporting continues this year, and that's for a few different reasons. We know that there's a lot of, concern and interest about getting a full data set this year. We have part of it because some districts have already reported, and this April was really the way for us to finish it up this year. So it's to complete out and get a fuller sense of all districts this year. We've been able to set it up so that they can do it easily, quickly, almost separately, but it's still through the same system. Once we're back in alignment next year, it'll all work together. But I think we can, for the field, pull it out separately pretty easily for them.
Okay. Let me just see who has not had a first shot at questions. I see your hand. Let's see, Ms. McClellan, you've got a hand up, but you don't really have a hand up, do you? Okay. Board Member Escarzaga.
Thank you, Madam Chair. Okay, Lisa, here. So you had me. So I've actually written improvement plans. I've done this for a long time, and you had me until just the last statement, then you lost me. So I want to double check. Will you not need the READ Act information every spring in order to make determinations of eligibility for funding for the next year? Wasn't that part of the monitoring?
So my understanding is that we're going to be collecting this information annually. That READ Act information will be asked of districts annually, and so that is not changing. Unfortunately, this year, it's first year, we just got caught up with the COVID flexibility and these kind of complex timelines. So that's why it feels a little bit funny this year. But, you know, beginning next year, again, assuming that everything goes as we are proposing, then it'll all come in October. You know, we have a couple, we have some districts that may submit a little bit later. Let's say if request to reconsider is back in process and we give them more time. So those wouldn't be till January, but we've really tried to consolidate all the timelines into one.
Okay, so October for the READ Act information is fine. And then also I know it'll work for accountability for schools that are on priority improvement or turnaround, that you'll have that data, in fact, even earlier than what normally. Okay, that's all I wanted to double check. Thanks.
Exactly.
Board Member Durham, do you have any comments, questions?
No questions, thank you.
You're hungry.
Yes, ma'am.
Have I called on everyone? So just to kind of close this up, the suggestion that we have improvement plans strictly for compliance purposes is deeply troubling to me. I really hope that we can convince our districts, no matter when it is, I mean, it does matter when they do it, but that it has a real purpose, that it has a purpose that is truly a plan on how they're going to move forward. And I'd like you all on staff to keep that in mind in order to be able to explain to districts, this is what we're asking you to do, which is to analyze your historical data and the status of your kids, and then develop a plan that will generate some improvement or some growth or whatever it is that their goal is. I'm getting myself kind of twisted around with all the different timelines, simply because those timelines to me have to make some sense for the people who are engaged in the compliance. And I think, aren't accountability committees a part of that improvement plan? So it's got to make sense to parents as well as the staff people. And I'm assuming we no longer have improvement plans that are developed just by a few administrators, which was what was happening historically many years ago, right? We're pretty sure. Do we have parents sign off on them? We don't, do we?
Madam Chair, no, the DACs, the district accountability committees do not sign off. It's just really contact information, and then local boards, depending on the plan type, sign off. Okay. That is something, that is something certainly that you can direct us to do if we're adjusting rules, but that is currently not part of the process.
Yeah, it's not my desire, however, to make things more complicated. But I do think that this is a plan that ought to be a plan that has a high level of engagement across the school district. So I don't know what the best way is to, and I don't know that we can ensure it, but we certainly should encourage it, in my opinion. Any other comments, colleagues? Okay, now we'll try for lunch again. I think I have some hungry colleagues. I have, I don't have the time anymore. I think roughly 12:15, so can we come back at 1:15? Does that work for everyone? Great, thank you, see you then, bon appetit.
All right, Madam Chair, we are now live.
Thank you. We'll now have a short presentation and vote on the Regis University request for reauthorization of its traditional educator licensure program. Commissioner?
Yes, thank you, Madam Chair. I'm going to turn this over to Dr. Colleen O'Neill and Miss Mary Bivens.
Thank you very much. Thank you, Madam Chair. Good afternoon. We're here, Mary and I are here today to talk with you a little bit about the 2020 Educator Preparation Reauthorization Review for Regis University. Mary Bivens will be showing our slides as we go through, so I will try really hard to keep up with her. But as a quick overview of what we're going to be talking about today, first, we wanted to take a moment to congratulate our two new board members, Board Member Escarcega and Board Member Esser. We have added a couple of things to our presentation today to make sure that you have some background in educator preparation program processes between the Colorado Department of Education as well as the Department of Higher Education, and then as a quick review for the rest of the team. So today's agenda includes a high-level review of the educator preparation programs, as well as, let's see, I just lost my place, so I apologize. A high-level review of the ed prep programs, as well as a deep dive into the Regis reauthorization and the recommendations. So with that, I will see if Mary Bivens wants to show her screen, or if she's trying, we'll just dive in.
I'm sorry, are you guys able to see it? It shows that it's sharing.
It is not there, Mary.
Let's try that. I stopped and started. Did that work?
Yes.
Okay. Yes, you're right there. Beautiful. Thank you. So across Colorado, there are 48 approved educator preparation programs, and that includes both our alternative and our traditional programs. The Board of Education and the CDE staff, in conjunction with the Department of Higher Education staff and the Commission of Higher Education, oversee the traditional educator preparation programs. Those programs are often referred to as our four-year programs, but they could also be master degree programs that lead to educator licensure or just educator licensure programs. Traditional educator prep programs focus on building content knowledge, such as math or science, and building pedagogy. So that is why they are considered our kind of traditional four-year bachelor degree granting programs. The State Board of Education actually has the sole responsibility for the oversight of all alternative educator preparation programs. These are 1 or 2 year programs that are on-the-job programs aimed at individuals who already hold a bachelor's degree or higher and have demonstrated content subject knowledge. And they're just looking to become a teacher. So the alternative educator preparation programs focus heavily on building pedagogy immediately and quickly for teachers in the classroom who are already teaching children. This is one of the areas where it's really about the science of teaching and not about the content, because the alternative teachers are becoming able with the content. Colorado is one of only about 2 other states that has as many pathways to educator licensure. We're behind 2 other states. We have 17 different pathways, and that includes one of those pathways is just our 48 educator preparation programs. We are behind only Texas and Florida as far as the number of educator pathways we have becoming licensed in the state. Okay. As we talk about our educator preparation programs, I wanted to point out just a little bit of the board's responsibility regarding educator preparation program reauthorization as it's delineated in statute. So pursuant to the statute, the state board reviews the content of educator preparation programs offered by the Institutes of Higher Education. And the key here in the State Board of Education's review is that you shall review all programs so that they shall be designed to ensure that the content of each program is designed and implemented in a manner that will enable a candidate to meet the requirements specified by you as the state board and the requirements for licensure endorsement adopted by the state, adopted by rule by the State Board of Education. And so we highlight that because This is the guiding principle and the guiding statute that drives the way that CDE staff approach the authorization and reauthorization process for both traditional and alternative preparation pathways. Based on that directive, the directives of the State Board of Education, we are not responsible, meaning State Board of Education is not responsible in any way for authorizing a degree program. So the State Board doesn't authorize a master's or a bachelor's or something along that line. That lives solely with the Department of Higher Education. But you are tasked with authorizing licensure programs that do lead, or educator preparation programs that do lead to licensure per your State Board rule. So I say that to make sure that we know, first of all, you have to authorize a program before it can be authorized by the Department of Higher Education. So just kind of remembering that split is that the Colorado State Board of Education really dives deeply into the content and the actual pedagogy of what's being taught to our teachers. Once you have that review or you make that approval, then it can go over to the Colorado Commission of Higher Education for ongoing reauthorization. So in this particular process today, what we're going to be looking at is the Regis reauthorization. And then we will, based off of your reauthorization, we will let the Department of Higher Education know that they can go ahead and take it to their Commission of Higher Education. This particular slide gives us a little bit of insight into the number of processes that it takes in order for us to get through kind of the entire review process with institutions of higher education. So as you take a look at the slide, which I won't read, you can come back to this often, and we provide it as a reference for the number of steps it takes to actually go through the reauthorization process. This is the same for institutes of higher education as well as our alternative educator preparation programs. So with that, I will turn to the strategic plan and where exactly kind of educator preparation sits within the strategic plan, the CDE strategic plan. What we know is that the goals of the strategic plan, and thank you. Sorry, I was just going to tell Mary that there's some notes on there. I was really interested in the dog. That's Stella and the dog. But then there's notes on your screen too. Not sure why. So I will let Mary figure that out, although I love Stella. That's Trisha Major's young daughter and their new dog, Bernie. So just in case anybody's wondering who that small child was, and the dog, we love them a lot. So we all have pictures of one of our team members' daughters and their dog. So let me talk just a little bit about where in the strategic plan the high-level goals live with regard to Educators Matter. So there are two places specific to educator preparation and programs. One is strong foundations. The strong foundations goal focuses on ensuring all students are reading proficiently at the end of third grade. And the Educator Matters goal is a focus because we know that teachers have a bigger impact on student performance than any other school-based factor. With regard to reading, research shows that proficiency in reading by the end of third grade enables students to shift from learning how to read to using those reading skills to master the more complex subjects in fourth grade and beyond. In fact, students who cannot read by the third grade are 4 times more likely to drop out of high school. By focusing on support for our youngest students and their educators, we can ensure more students are reading on grade level by the end of third grade and build a strong foundation for continued success in school. We say this because you're going to hear this as we talk about our educator preparation programs and our reauthorization. Specifically, you're going to hear us talk about reading as we go forward. The work that Regis University has done to help teachers learn how to teach reading using evidence-based strategies is deep work. It takes faculty members who understand the evidence-based practices in a wide and a deep way. It takes the understanding that evidence-based practices in reading must be used as the core foundational method for all teachers to teach students how to read. We cannot say this enough. We cannot just be using an intervention that use evidence-based reading strategies. We must be using it as our core teaching strategies. Evidence-based reading strategies are the core of the foundation and the one in which educator preparation programs instruct our preschool educators on. That is one of our core foci currently as we work with our educator preparation programs. So with that, I'm going to turn this over to Ms. Bivens, who will point out for us how we're continuing to collaborate where we just landed, how we're continuing to collaborate with them, and how we're going to support some of the findings that we have from the Regis University reauthorization. With that, Mary.
Thank you, Colleen. Good afternoon, Madam Chair and members of the board, especially for our 2 new members. I will be talking, I'm hoping you're seeing my screen. I keep getting bounced out of the system, so my apologies if you're not able to see my screen, but please somebody give me a head nod if that's not working. But I did want to talk to you a little bit about Regis. Specifically, as Colleen teed up for us, we've been working with all of our preparation programs deeply, and Regis had their reauthorization scheduled originally for March of 2020. They submitted their materials to the Department of Education in the winter months of 19 and 20. Just days before that scheduled site visit, the decision to postpone the reauthorization visit had to be made due to the COVID-19 restrictions. The initial peer review of what Regis submitted to the state was done in the winter of 2020, looking for alignment to the State Board of Education endorsement standards in all of their identified programs. During that initial peer review, there was an identified area of focus around the teacher candidates training in evidence-based reading strategies in Regis's elementary and their special education reading courses. Based on the university's submission and the peer review findings, CDE worked with Regis to adjust the site visit schedule. We added additional site team members and additional time to delve deeper into the instruction with current candidates, former candidates, our K-12 partners, and the university leadership and faculty. With the delay in the original site visit date, Regis University was able to continue some of their scheduled course revisions, and they provided additional submissions for reviews, and that happened in the summer of 2020. The rescheduled site visit was just this past October. It did also have to be conducted virtually over 4 days due to the continued limitations from COVID-19 restrictions. Sorry about that, the screen's acting up again. The site visit consisted of a full state review team. It included a district partner, university peers, and it covered all 4 of the licensure pathways available at Regis University. All stakeholder conversations occurred as they would have if we had been in an in-person site visit, including conversations with current and former candidates, university leadership and faculty members, and K-12 partners such as principals, mentor teachers, and district leaders. Based on the preparation that the faculty did for the submissions to CDE in the winter of 19 and 20, as well as the university's combining of all of their educator preparation pathways into one school of education, some course redesign was being done prior to our state reauthorization process, focusing on deeper alignment to and depth in those emergent reading strategies in their courses. One example of that is the post-traditional pathway had redesigned a key reading course that both their elementary and special ed candidates have been taking in the past year. They've continued with additional reading course redesign since our visit this last fall, and those changes have already been incorporated into this spring's and this upcoming summer courses. During our site visit, the faculty were very open to collaborating and working around the state's expectations around the science of teaching reading and how they could continue to improve their content and delivery in the coming months for their current candidates and in the future. Since our site visit, the faculty have met with CDE reading specialists to ensure the continued enhancements to their courses are utilizing the most recent research and aligned to requirements in state legislation and rule. Based on the state review process, CD staff recommends for the board's vote today, reauthorization of all but 2 of Regis University's endorsements. Those exceptions would be for their elementary and special education programs, and for Regis to participate in another state review site visit this fall. The conditions for that conditional reauth of those 2 programs is outlined in detail in the December 2020 final reauthorization report that has been shared with you. They are aligned to all of the elementary and special education programs, no matter what pathway they are through, undergrad, grad, post-bac. And they are aligned to the State Board of Education reading endorsement standards. And we have requested an additional site visit this fall to check in with stakeholders to confirm changes have been put in place by leadership and the reading faculty around scientifically based reading instruction. Colleen, I'll send this back to you to wrap up and to take any questions we may have from the board.
Thank you, Mary. I appreciate it a lot. You all hear us on the board talk a lot about teaching reading. Please know that we are conducting the same level of review for every single endorsement area. We have over 60 endorsement areas that we offer for educator preparation. And I think it's important to know that we really do take this care for everything. We continue to bring the reading back to you because we know it is a high priority and we know it's one of the most critical skills that we need to ensure our children have in order to be successful and lifelong learners. So we often also find that it is in teaching reading or teaching teachers how to teach reading that is the most difficult for educator preparation programs. And so that is why we have a continued and ongoing commitment to the reading focus for all educator preparation programs. CDE staff at the direction of the board has been deeply monitoring all ed prep programs, including our alternative and our university programs. Specifically for our traditional ed prep programs, we do that, of course, in concert with the Department of Higher Ed. And then for all ed prep reauthorizations, we are working cross-departmentally within CDE to help include the subject matter experts that know the most and understand how best we need to prepare teachers to teach reading to our children. And that includes the Educator Talent, Educator Preparation and Support Office, the Exceptional Student Services Office, and then our Teaching and Learning Unit as well. CDE staff continues to work hand in hand with all of our team members here at CDE and with our programs to support high quality reading programs that are focused on ensuring our teachers know how to teach our children to read. The CDE Educator Talent staff also just wanted to let you know that we have been meeting approximately once a month with anyone who has been conditionally reauthorized. We provide technical support. We offer open office hours. We are on the ground with those university or alternative preparation programs. Right now, we've been meeting mostly virtually, without face-to-face interaction. But this spring, we are also coordinating, again, cross-departmentally within CDE to have course offerings in evidence-based reading, specifically aligned around the READ Act for all education preparation faculty who teach reading. And so we will be launching that as soon as we can get all of our I's dotted and the T's crossed and all of that in place. It will not be a mandatory training. It will be optional, but so far we've had really good feedback from the field asking about our opportunities to learn more, to engage more. And so we're establishing all of those opportunities this spring with hopes that we can follow up with some more opportunities for our educator preparation faculty to really dive into evidence-based reading and scientifically based reading research and the READ Act requirements specifically, so they have a better hand as we teach our teachers how to teach reading. So with that, I will stop there, and we're happy to take any questions that you may have before the board votes on a reauthorization of the Regis Educator Preparation Pathways.
Thank you. Before we get to questions and comments, I would like to entertain a motion, please.
I can do a motion, Madam Chair.
Thank you, Dr. Sheffel, please.
I move to approve the reauthorization of all but 2 elementary education and special education programs at Regis University's educator licensure endorsement programs.
Thank you. Do I have a second?
Second.
Thank you, Board Member McClellan. Board Member McClellan, do you have any questions or comments, please?
Thank you very much for the presentation and the deep dive, and especially thank you for your efforts around evidence-based reading instruction and scientifically based reading instruction. Thank you.
Thank you. Board Member Esser?
Thank you, Dr. O'Neill and Ms. Bivens. I am going to recuse myself as I just retired from Regis University and bleed a little bit blue and gold still. So thank you.
Totally understandable. Thank you so much. Board Member Sheffel.
Yes, thank you for the presentation. I wonder if CDE, Colleen and Mary, if you could talk about how the universities are responding to this. Are they saying things like, yeah, we'll do this, but you know what CDE could do to help us, or what the board could do to help us would be A, B, or C. You know, I know that there's a real challenge with curricular space and creating programs that are competitive. And, you know, there's always a tendency to keep adding and adding and adding courses when there are new requirements. And the universities are like, hey, yeah, we'd like to add all these courses, but we wouldn't be competitive if we did. And we have to address all these standards, and how can we look at, you know, priorities. So I just wonder what they say, what their thoughts are, and is there anything we can do to support the universities as they're trying to align with this work? But we know that they have many targets that they're trying to hit, also many, you know, requirements.
Yeah.
Dr. O'Neill?
Yeah, thank you. I'll start and I'll let Mary chime in because she is face-to-face with a lot of these folks every day. The answer to your question, Dr. Sheffel, is yes. And this is, I'm happy to say that because I think I had a similar question about a year and a half ago, and my answer was not so much. Today, that answer is yes. Our educator preparation programs are leaning in heavily. They're asking for support from CDE, and they're willing to work with us in very different ways. They still recognize the challenges, especially around faculty, and bringing our faculty teams up to speed and how we can help them. And some of that is some of the manifestation of what we're doing to support them is a direct result of those educator preparation programs, their deans, their directors, and when we're talking about our BOCES programs, and their faculty stepping forward to say, we really do understand that we have a gap and we want you to help us fill it. And so with that, I'd like Mary to talk maybe a little bit about some specifics that she's encountered just in the last several months even.
Absolutely. Thank you, Colleen. And thank you, Dr. Sheffel. It's an excellent question. You know, Colleen said it well. Some specifics I'd like to share. I literally have a list growing of people who are just waiting, so excited that we're going to be able to offer some training to faculty. Both are traditional programs. You know, here we're talking about university faculty, but also we are supporting several of our alternative BOCES programs who often have smaller cohorts. For instance, a small alternative program may only have 1 or 2 elementary teachers every year. Right, so they don't have a whole cohort. And so their challenges, Dr. Sheffield, are very different than the universities, but similarly tough in that how do we build this rich, deep content for one person or one person every other year? And so we've been coming up with really creative partnerships between universities and those alternative programs, joining some of those smaller alternative preparation programs at BOCES together to build a cohort to support the smaller amounts of programs. So we're really, really excited. Colleen's point that we're getting a lot of leaning in is very, very true. it's now versus maybe what it was a year ago. And I think they recognize the board's continuous efforts and appreciate and value that. But they also really feel like CDE is holding the line, but also in a supportive growth mindset. So I think that's why we're getting so much lean in. The last thing I'd say specifically, you're wondering, Dr. Sheffield, about the capacity to add more things in. With reading specifically, in the programs where we've been supporting over the last, we started this deep dive in October of 2018. So in the last, 2+ years, really has been shifting their coursework a little bit more than having to add it. Some are adding, but it really is changing a focus to, as Dr. O'Neill mentioned earlier, to this reading being foundational, not intervention, or not in a menu of ways to teach reading. So that's a shift and doesn't require necessarily always more, but a little bit different. So I hope that's helpful.
That's helpful, and I'm glad it's not viewed as punitive, because it's really a partnership. And having taught literacy courses all around the state for various universities, I don't think I've ever taught a class in that where the teachers in the class haven't been appreciative of it. It's like, yeah, we need to learn this. We want to have this. And I think that's the general attitude, as long as it can be, as long as logistically it can work. So I appreciate all the work you're doing to make this happen. And also kudos to the universities for really looking at it seriously and being willing to, change as needed and still honor the strengths that they have too. So thanks so much.
Yeah.
Thank you. Board Member Rankin.
Extended warranty programs have been introduced that could save you thousands of dollars over the next few years. If you have not responded to this notification, it's not too late. Don't make the mistake of driving without a warranty.
Somebody have their answering machine on?
Voice a little deep.
I don't know where that came from.
I don't know where that come from. Yeah.
It came from me.
I
not get constant all-day calls. And if Wayne doesn't pick the phone up fast enough, we get the message. Sorry, Board Member Rankin.
Okay, thank you. I have great concerns about this, the programs that we are talking about, and I want to start out by saying to Colleen O'Neill, you have done a yeoman's job at reaching out to these universities and colleges and districts and to me and helping me understand. But in the last time we approved an authorization and we're promised all of these things are great and going to happen. I wanted to vote no then, and I didn't, and I've rethought that. I think I made a mistake there, and I'll tell you why. We're waiting for CDE rollout. If you're a professor teaching reading at the college level to people that are going to go out in the field and teach it to K3, which are the most important years to learn reading, I throw in that term urgency. We have an urgent helplessness at the K3 level, and it's not like it just happened overnight. However, people are just starting to listen to it. But this bill has been out there and in place since 2014, and now it was put out there, but with more accountability to it. And I am finding that people at the teaching level, at the college level, are still saying, what is it? What is it we have to do? And these reauthorizations come once every 5 years. There's a group of kids, many groups of kids, that have gone from 2014 till now, K3, and have not been taught the science of teaching reading, which is evidence-based and proven, which should be such an aha moment for teachers, for professors to embrace. And I will be a no vote today, and I'll tell you why. I can't wait another 5 years. And all we're doing is giving these subsets of it a second chance. We did that before to one of the schools. And when I was looking at this proposal, I was looking at the last school which was probably the first that we approved, holding out that reading till they learn to do it. Maybe they'll learn by October. You're going back in to see that. Maybe that'll happen. Maybe it won't. But we've got 5 years before they really have to come back. Or do we reauthorize those two parts? Okay, I revisited the website of our past school. And this was just a few months ago. And if I was there, I would make sure that we would say, hey, we're down in these two areas. And here's why. And here's what we're doing. Students come to our college because we are going to have the best. We're the latest and greatest because we're telling you about this right on our website. Their website says we have received full, unconditional accreditation of all teacher education programs. Now, I'm not saying Regis is going to do that. I'm not saying it. I'm just saying I'm looking at what's happening and I'm not seeing it for our kids. And it's that urgent helplessness that is causing me to vote no today. And if it draws attention for more universities and more teachers to get on board, wonderful, wonderful. I hear there are some going through our course right now at CDE that are saying, I was taught reading, but I wasn't taught this way. They're having aha moments and spreading those. What else could we hope for than that from CDE and the reading area? So I just want to explain where I'm coming from and where I hope we're going to. But for now, it's going to be a no vote. Thank you, Colleen.
May I ask a follow-up question, Madam Chair?
Yes, Dr. Sheffield, go ahead.
I thought that you were saying, Mary and Colleen, that you were approving all the programs except elementary education, and was it special education, right? And so, Board Member Rankin, are you referring to the other programs, or are you, in other words, I think what they're doing is withholding on those two programs until some of the alignments and changes are met. Can you speak to that?
Yes, I can. And this was the same agreement we made with this other school. So therefore, if we say conditional, well, 5 years from now, they'll be there and we can say, okay. I look at it as what college is putting out there for all of the elementary teachers. And what's the most important thing we're putting out there? It's reading, and it's reading instruction. If we did nothing else but teach reading, our students would be successful in life. That's the one core basic, and to even put it off 6 months, when those professors could have taken, there's some online courses, just out of curiosity. And I'll talk a little more about that when I give my board report today, because I have heard some things that are extremely successful. But Board Member Schroeder, I just think we need to stand our line, and I think it's either black and white, because I don't want to see us going down a path, this, and this are okay, but this, and this aren't. And I want these universities to say, hey, we're doing it, and we're doing it right for all of the elementary school teachers. So thank you for that question.
Board Member Rankin, allow me to ask you a question. You've gone back to, I believe, the higher ed program that we have turned down 2 years in a row, their elementary, or I'm sorry, given them just 1 year extensions 2 years in a row. And are you saying that on their website they are not acknowledging that they have limited accreditation for elementary reading?
That's what I saw this past week, yes.
Thank you. I think maybe a follow-up from our staff would be helpful to confirm that information and maybe to have a conversation, because that's pretty frustrating to think that we've actually got two programs. Twice we've given a conditional and one just once. And I think maybe there should be a follow-up on what they are telling their candidates, just in the interest of Yeah, just in the interest of being a candidate. Board Member Durham, I see your hand up, and I think it's your turn anyway.
Thank you, Madam Chair. I just had a question for Dr. O'Neill with regard to the University of Northern Colorado. Are they still on the probational for their elementary education and reading programs?
Thank you, Board Member Durham. Yes, they are. They are still on conditional approval. We did one more year of conditional approval. That will come back up again in the fall. We've been working with them hand in hand over the last several months as well to try to get them to come into compliance. They completed some faculty training earlier this year, specifically around the READ Act. And so we do see progress and movement towards that. But we will be looking at their program again in March, and then seeing where they land. And if it appears that they have met those requirements, we'll come back to the board. If it appears they have not met those requirements, we will come back to the board and have the board make a decision as to what to do next for the University of Northern Colorado's educator preparation programs.
So you'll be back to the board regardless this sometime fall after your March.
Spring. Mm-hmm. Yeah, it'll be in the spring, actually in just a couple of months. So with conditional authorizations, when the board approves them, there's actually timelines and deadlines tied to those. They don't go any longer than a year. So what's happening is we're reauthorizing all other programs and kind of taking them off the plate. And then the conditional reauthorizations are not authorized. They're conditionally reauthorized if they meet these requirements within this time frame. And so CDE has made a recommendation, CDE staff has made a recommendation twice for the University of Northern Colorado that we can go ahead and give them one more year. That happened last year. We will look at it again in March, bring it back to the board likely in the April-ish timeframe. It could be made depending on the board's agenda and the number of things on the agenda. And then we could possibly make recommendations for everything ranging from do not approve them at all to probation, which means they wouldn't be able to accept any new candidates in. They might be able to finish the candidates they have, but until they can demonstrate a change, they wouldn't be able to accept any new candidates in or fully authorize them at that time. So we'll be bringing both of those things back or all those things back for UNC. The other one that you have done this on is the Metro State University. We did this last year as well. They will also be up for the conditional review happening in March of this year as well. So you will see them again to see what their progress has been.
Okay, and then, so would you mind, checking the website? If they're claiming that they have full approval, that's, we're not the Federal Trade Commission and don't control truth in advertising, but I think that would necessitate some sort of reprimand from the commissioner or one of the staff people.
Okay, thank you. We will absolutely do that.
Thank you.
Board Member Skarzica.
Thank you, Madam Chair. I have a technical question, I guess, for a newbie. If I'm a student and I'm in, say, year 3 of a 4-year program that gets shifted to provisional, or let's say they get unapproved for a year, and then the next year you all, I've always been looking at the board, now I'm one. We approve them. Does the student graduate from an approved program? I mean, I'm thinking of it from the student's point of view. Is that why, in part, you do the provisional so that the student is still going through an approved program, or maybe it has nothing to do with it?
No, actually, Dr. Skarzica, you are right on track. So we do not ever want to punish anybody who's going through a program, ever. And so we've had this actually happen to us a couple of times where individual programs have sunset themselves because they made it through our reauthorization process and we're like, oh, wow, we're not going to ever meet this, are we? And the answer is no. And so they have chosen to sunset themselves.
And in those cases, we transition students over to other universities and we work with them to accept their credits. We work with the Department of Higher Ed to do that. We've done it with alternative prep programs too. For probationary status, what we're talking about with possibly one of our higher ed institutions, probationary status would be exactly that, is we're allowing them to finish the program. We recognize the holes. We will do the best to fill the holes, but we will not let any more students into those programs. And we will encourage individuals in those programs to find different educator preparation programs, and we will help facilitate that transfer if they want to do that. So we have done all aspects of that in conjunction with our team members at the Department of Higher Education.
Okay. And then if I could, just a note on the motion, it just says to approve the reauthorization of all but 2. It doesn't say to conditionally approve the other 2. It just says reauthorization but the 2. You see the way the motion reads?
Let me take a look. I was thinking we had in there all but 2 and then another sentence with a conditional reauthorization pursuant to the board memo. Does it not say that? I apologize, I don't have a script in front of me.
It does not. The motion was just, oh, whoops, I'm in the wrong place. Pardon me, let me go back.
Okay. It should have had a reference. I believe the one I looked at had a reference to what the conditional authorizations that was already stated in the board memo.
It's not on there. So there's a second sentence that should be amended to that motion.
Which should be referencing the board memo, yes.
1 year conditional. Or exactly, help me.
Let me do just a little tiny bit of looking here for a second.
So we get
Mary's gonna look for us too. Yeah, there should have been one more little piece in there that said
that the 2 accepted programs be conditionally approved, provided that the reauthorization conditions are met. That doesn't help me very much, Dr. O'Neill.
Okay.
So I'm going to let you guys work on that part of the motion. I have a question about why it's Regis is only being renewed after 10 years. What happened to our 5-year schedule?
So that a lot of the renewal schedule is dependent on the Department of Higher Education and other things. So originally Regis should have been renewed, I think, upwards of almost 3 years ago. They had the data breach last year. And so there was a data breach that prevented us from doing that. And then there was the pandemic that prevented, so it got kicked down just a little bit longer. But those are set kind of by the Department of Higher Education and some of with some input from us and in some cases not as much input from us, but we do that together under the same statute.
Can we push a little bit to make sure it's 5 years?
Yes.
Please?
Yes.
Do we have the, I guess I should ask the commissioner because I don't want to get anybody in trouble, but I mean, I realize it's 10 years, but it's not 10 years because of the last 5 years.
Right. Yes, we can certainly push on that. And I do think that if we conditionally reauthorize, Ms. Bivens has put the extended motion in the chat that highlights the conditional. And if we do that, we will be revisiting them in, first of all, in a few months, but then it will come back to you in a year. So you will not be approving these 2 programs. You will be approving their other programs. You will not be approving these 2 programs so that you give us some time, as you have with other ed prep programs, to work with them. They will come back to you in a year to look at those conditional approvals. And That's what this motion in the chat says.
Dr. Sheffel, are you up for modifying your motion? I believe you made the first motion. Did you
Should I
not?
reread the whole thing?
Yeah, are you in the chat? Can you read it?
I'm in the chat, yes. It is the, so the motion will now include language as follows. It is recommended that the two programs not approved be conditionally approved, provided that the areas for improvement as detailed in the December 2020 reauthorization report and State Board of Education memo are met.
Thank you. I think that's still a proper motion, and I believe, Ms. McClellan, did you second it?
I did, and I had another question when you're ready.
I know your hand's also up, but are you fine with that so that we have the right motion on the table?
That much so far, yes.
Okay. Board Member McClellan, go ahead.
Okay, thank you so much. So I had a couple of concerns and questions. Some of the feedback that we've had on the READ Act teacher training requirements touched on hours and cost and the burden for the teachers. And I just don't know that it's being communicated to them that this is a gap that resulted from the omission of this important material in their original teacher prep program, with the exception of those who did this kind of training many years ago and simply couldn't find the paperwork to show that many years later. But in many cases, for newer teachers, it may be that they are having to go through this process now because their teacher prep program didn't cover the science of reading. So do we have any ability to include a disclosure requirement for these schools that have this gap still? That's the first question. And if so, I might need a helping hand with an appropriate amendment, though it probably shouldn't be all that hard. But then the other question I had was, will we be in a situation where we are applying rules or enforcement in an arbitrary manner if we treat Regis differently than we treated UNC? So that's kind of the struggle that I'm having with this case.
Madam Chair?
Go for it.
Okay. I think, there's a couple, this is a layered, first of all, it's a really valid comment. Thank you for making it. It's a layered approach, and I think we can take board direction and recommendation at any turn, and I would welcome that. So the layered approach at this point with our educator preparation programs has been to make sure that we do a deep dive into the teaching of reading based off of the education rules. And then what we've been doing is, on top of that layer, we have been extraordinarily active in trying to get our educator preparation programs to create courses and end of course assessments that would meet the READ Act requirements specifically. Apply for those. We're working together with the Teaching and Learning Unit in the P3 office, who oversees the READ Act, to align our educator preparation courses directly to those requirements, get approval from the Colorado Department of Education so we can immediately give it to the teachers. So there's no, lack of clarity around that. Board Member Rankin has asked this question a few times of me, and I keep kind of saying the same thing, is that there's really nothing that requires our ed prep programs to do anything that really meets the READ Act requirements outside of teaching solid evidence-based reading strategies. They should be doing that without question. But it's that end of course assessment that's hanging people up. There is not usually a specific end of course assessment for teaching scientifically based reading strategies in our university or any of our educator preparation programs, unless they have adopted something from the Colorado Department of Education, like letters training or something along that line. So we're working hand in hand with them to try to get people exactly at that point. And yesterday, I believe our board chair talked a little bit about what is it that we can do, instructed staff to come back to the board with what is it that we can do to make sure that our alternative preparation programs and our Institutes of Higher Education educator preparation programs are aligned. And so we want to come back with that information. The board has adopted a Praxis assessment 5203 that individuals can use as an end of course assessment if they have taken all of the appropriate courses to validate that. And so we think there's opportunity that we want to discuss internally with staff and with our universities and our educator preparation programs to come back and really take a look at the Praxis 5205 and use it as possibly one of the tools for our EdPrep programs to become holistically aligned. That's a bigger conversation. I think Board Chair Schroeder, boy, I'm going to get them all confused this afternoon, has given us some instruction to do that. If there's further instruction, we're happy to take it, and we can come back with other recommendations as to how we can make sure that we can sync some things up so that it's very clear what the expectations are and what our teachers are leaving their educator preparation programs with.
Is it possible, would we be considered arbitrary if we were to make the demand of Regis and of any other schools that we may find before us in a similar circumstance, that there be truth in advertising and that this be disclosed? The challenge I'm having is if we didn't do that with UNC, it may be difficult for us to do that with Regis. So I don't know, maybe I need to hear from an attorney on this one, whether or not that's, if we had a hole in the way that we handled it last time, does that mean we have to persist in having a hole in the way that we handle it next time? Because I sure don't want to have a situation where this isn't being communicated well to the students in these programs who then will graduate and potentially have a new requirement with us that they wouldn't have had their university covered it the way that they are supposed to be covering it.
May I make a comment, Madam Chair?
Yes, Board Member Shuffle, go ahead.
Yeah, I think there's a lot of legal issues here because this authorization process is perceived as peer review in concert with the relevant entities, the Department of Higher Ed and then CDE. So I think that we should look into that. I mean, there are a number of categories that CDE and CDHE look at when they're authorizing programs and diversity and a lot of issues. And if you're asking all the universities to put that up, then everybody would be out of compliance because nobody's really putting that on their website to say, well, we were dinged on this category and, we're working on addressing it. It's perceived as a continuous improvement process, not, you're in this bucket and until you fix it, you're kind of out of compliance. I mean, everybody has areas they're working on. So I think that we'd want to be consistent across all the universities and all the categories.
Board Member Rankin, you're smiling. It's not because you're happy. So thank you.
No, I just opened up a big old mess, I think. But it's not something I haven't given a lot of thought to, I'll tell you.
So Dr. O'Neill, I think we've got some more conversations to have. I'm not entirely sure that I'm able to direct you, but some thinking among staff would probably be helpful. I see a hand up, but it's not attached to anybody. Does somebody have a hand up that should be taken off? Board Member Durham, did you still have your hand up and you were finished? Yeah, there we go. Okay.
Just could someone please reread the motion for me, the full motion?
I could reread it, Madam Chair.
Please.
I move to approve the reauthorization of all but two parens elementary education grades K6 and special education ages birth through 21 of Regis University's educator licensure endorsement programs, with the caveat that it is recommended that the two programs not reauthorized be conditionally approved, provided that the areas for improvement as detailed in the December 2020 reauthorization report and State Board of Education memo are met.
I apologize, but I don't quite understand. does that constitute then, let me ask Dr. O'Neill, does that constitute an automatic approval if the university should, if they should just simply assert that they now meet the program or now meet the standards, or does it come back to the board and for evaluation of that assertion?
It will come, thank you, that's a good clarification. It will come back to the board. So it will come back to you once the conditional reauthorization, if that has been met, or after the ended period of expired was the word I was looking for, expired period of time, then it will come back to you with staff recommendation as they met it. They did not meet it, and here's what we'd like to do about, make a recommendation, and then you can give us instruction as to how we go forward with the rest of that authorization for those programs. Just those programs.
Okay, so do you believe there's adequate clarity in the motion as stated, so that there cannot be a claim that they've met and somehow they've met the requirement, somehow we've ceded our jurisdiction to evaluate that claim?
So I want to take just one moment, because I think your question necessitates a transparent answer. And I believe, and I will go back and I will check UNC's website. I believe there could be confusion from UNC between what the State Board of Education, you all, approved as conditional and what the Colorado Commission of Higher Education approved for them and sent them a letter on. And so I'm going to be 100% transparent in, I believe, based off of what you have said, and potentially some other conversations, that I need to go back and review the letter that was sent to the University of Northern Colorado from the Colorado Department of Higher Education and the Colorado Commission of Higher Education, and see what they approved and what they did not approve, so that I can seek clarity. And if those two things are not aligned, I will make sure that they become aligned and that the University of Northern Colorado is crystal clear as to what the Board of Education has approved.
Yeah, but I was actually trying to make sure that we just have proper motion that for the Regis case, that because whatever's been done is done with UNC for the moment, but that it's clear that there's not some sort of automatic path to compliance, that essentially the State of Education retains its jurisdiction and has the final say on whether or not they have achieved whether or not they've achieved compliance. And it just doesn't sound to me like that's what our resolution says, although I might be just overly nitpicky at the moment.
I understand, thank you. It is what's detailed out in their conditional authorization or in the report itself, that I think it's pretty clear in the report itself that if they don't meet these requirements, they will be coming back to the state board. Well, they'll be coming back to the State Board of Education regardless. But we're more than happy to go through that if needed.
Ms. O'Neill, I'm working a little bit on the motion right now, because what Ms. Bivens put in is not technically a motion. So I'm working on another one right now that tries to clarify this. Ms. Tolleson, if you're there, you may just watch the chat and make sure I'm putting something that would work. But because I'm kind of doing it on the fly here.
Yeah, it just didn't seem to me to be
right.
That encompassed what it ought to encompass.
Right.
Just in case anybody gets litigious about it.
Meanwhile, did I have another hand up? Mrs. Skarzica, did you have your hand up?
Yeah, I think what I was perceiving Member Durham to say is part of the conditions for them that they have to come back in front of the state board first and get our approval.
Yes.
Or that's the question, because if it's in there, they can't assume they got it till they come back to the state board. I think that was what I was looking for. Yeah.
Right, and that's what I was curious about. I just didn't hear it. Maybe I missed it.
Gotcha.
Almost there here. all.
Madam Chair, may I ask a follow-up question?
Please do, Dr. Shuffle. Go ahead.
Categories too, Colleen and Mary, that you use when you review university programs for authorization or reauthorization, it might be helpful to review those categories too, because there are ways to ask universities to make changes without saying you're not approved. And so there's a number of steps there and a number of categories. So, I mean, I think this is kind of opening up a larger discussion of what are the categories. Reading's one, but there are a number of others. And then within those, you can have a statement made by the state that says, hey, work on this, without saying you're only conditionally approved. So, I mean, there's different levers there that maybe you would want to clarify.
Absolutely. Yeah, we can do that for sure, because there are multiple layers. There is approval and conditional and probationary and non-approval. So yeah, there are many levers. So thank you. We'll take that into consideration too.
Okay, I gave it a shot. Ms. Tollison, can you read what I wrote? There may be some typos in there. I mean, can you just see if it's appropriate?
Yeah, let me take a look right here. I think that works just fine.
Okay, so Board Member Shuffle, you may have to put a motion on the table one more time.
Sorry, shall I read that now, Madam Chair?
Please.
Okay, so this is an amended motion. I move to approve the reauthorization of all but 2 elementary education grades K-6 and special education ages birth to 21 of Regis University's educator licensure endorsement programs. The elementary education and special education programs are conditionally approved and will have to come back to the state board to see that all requirements as outlined in the December 2020 reauthorization report have been met before being reauthorized.
Do we need a time frame on that?
It is outlined. There is a time frame that's outlined in the statute itself, or not in the statute, in the report itself. When it says as outlined in the December 2020 reauthorization report, there is a timeline in there.
Okay. All right.
Do I have a second, Board Member McClellan?
Second.
Thank you. Are we ready to vote on this, colleagues?
Do we need to indicate that that's a replacement motion? Do we need to formally indicate?
I do think that Board Member Shuffle said it was an
amended.
What did you say, amended or replaced?
Amended, or it can be a replaced motion.
Is that okay, Mr. Durham? We do replace the motion? Okay. Ms. Miranda, would you call the vote, please?
Board Member Durham.
Yes. Madam Chair, I have one more question, if I can.
Oops. Go ahead.
This is Joyce.
Yeah.
Dr. O'Neill, it seems like in the past we've used the word accreditation and now we're using the word reauthorization. Are those simultaneously the same, or?
Right. Yeah, no, we try really hard to use the word reauthorization because accreditation usually refers to the regional accreditation that our institutes of higher education have to have in order to operate as an institution for the Department of Higher Education. So we try really hard to use reauthorization or authorization, if you will, in the language for CDE.
Okay, so even in the past, we've used authorization, correct? I thought it was accreditation, but as far as we're concerned at our level K-12, it's authorization and it's 5 years, but the accreditation that's not in our purview is also 5 years. Is that correct? Okay.
Yes, yes.
Thank you.
Okay, let's try that again, Ms. Naramba.
Board Member Durham.
Yes.
Board Member Sarzica.
Yes.
Board Member McClellan.
Yes.
Member Rankin.
No.
Board Member Shuffle.
Yes.
Board Member Schroeder.
Yes.
That passes 5-1.
Thank you very much.
Thank you.
All right, our next two items are, no, the next item is school finance. We'll have a short presentation and vote on the certification of state share of entitlements pursuant to the School Finance Act. Commissioner?
Yes, thank you, Madam Chair. I'm going to turn this over to Ms. Jennifer Oakes.
Hi, Ms. Oakes.
Hi, thank you, everybody. So this is a presentation that I come before you typically 3 times a year. So we start out at the beginning of the year, and I request that you certify the state share payments at the beginning of the year for August through November. And then I come back today to ask you to certify December. And then I will come back next month to ask you to certify January through June. There's a potential in any given year that I might come a 4th time just because this is very exciting. But if the legislature decides to do a supplemental mid-year adjustment that is different than just simply a true up to pupil count or assessed valuations, for example, adjusting the budget stabilization factor, once that supplemental is passed, I would come back before you again. And so that's happened in prior years. So with that kind of as the big background context, real briefly, what we do is we take legislative council's numbers that are included in the School Finance Act at the beginning of the year, and that is what we make payments are for the first 5 months of the year. So we go through and we apply the school finance formula based upon statute, and that is what you're certifying. We have the mid-year true-up, which is essentially a 2-month true-up. So we have the student October count that occurs. Most of that is finalized in time for us to process the December payments. And so that's what's incorporated into these numbers in front of you. But we do have a little minor adjustments with student count or assessed valuations that gets incorporated into January. And so then those are the ones that will be final for the rest of the year without a supplemental adjustment. So what you're being asked to do today is to certify the December 2020 state share payments that was calculated to be $335,864,781.35. So I'm willing to answer any questions because that was a very quick overview of a very complex process.
What's the SWAP, SWAP?
Yeah, so SWAP is the School to Work Alliance program. And so that is a statutory program that allows districts that participate in that. It provides year-round individualized services to assist students and youth with disabilities on their career path. So it's a collaborative initiative between Division of Vocational Rehab and the Department of Human Services, or I'm sorry, the Department of Labor and Employment and the Department of Education. So it's districts that agree to participate in that, and then we, based upon their participation, move money accordingly to their participation. So it's really at the district's just direction through their participation in that program.
It doesn't take money away though, does it? I mean, I'm trying to understand, nothing goes across here for my accounting nature. And so.
Right, so if you go to that second sheet, which is the big long spreadsheet, so the monthly entitlements that you're certifying is highlighted in yellow. So that's again the calculation that we make. We do make a number of adjustments. The swap is the first year or the first column of adjustments. So if you look at Mapleton, based upon their participation and how all the calculations work out, we make an adjustment of $7,399.16. So we don't pay Mapleton, we adjust their actually monthly payment is adjusted for that. So that money goes to pay for their participation to swap. So we're sort of just peeling that money off and getting it where it needs to go.
So it's just going to a different place. It's not less money available for their kids.
Right. And so if we didn't do this, we would give that money to them and then they would turn and give it to the Department of Labor and Employment. This is just streamlines that process for the districts.
Okay. So I know that you are truly overworked, but in the future, could you put a little thing on the bottom that actually says what it is and what it does? So that we have citizens that look at this also and they're going, what is this? What does swap mean?
Yeah.
Just some kind of an explanation so that it's a little more self-evident.
Yes, we will definitely do that. We did, I don't know if it was a year or maybe 2 years ago, on the memo, we have explanations of that to provide it, but the memo and the spreadsheet. So we can do a better job of incorporating that into the spreadsheet portion of it. So we'll work on making that more clear.
I'd appreciate that because I think people look at that and wonder.
Yes.
I guess first I need a motion. Are you finished? I'm sorry, Ms. Oaks.
Yes.
Thank you. I need a motion, please.
I can do the motion, Chairwoman Schroeder. I move to certify the December 2020 state share entitlements pursuant to the School Finance Act.
Thank you. That's a proper motion. Do I have a second?
I'll second.
Thank you very much. Let me go down the line. Board Member McClellan, do you have any questions? Comments?
Not for me, Madam Chair. Thank you.
Board Member Esser?
No.
Scheffel? Oh, I believe she's en route. Yeah. Board Member Rankin? Do you have any questions?
No, no, thank you.
Board Member Skarziga?
No, thank you.
And Board Member Durham?
No, thank you.
All right. So there's a motion on the floor. Ms. Miranda, could you please call the roll?
Board Member Durham,
Yes.
Board Member Skarziga,
Yes.
Board Member Esser,
Yes.
Board Member McClellan,
Yes.
Board Member Rankin,
Yes.
Board Member Shuffle is absent, and then Board Member Schroeder.
Yes.
That passes 6-0.
Great. Next item on the agenda is a report on the October 2020 student count. Commissioner?
Yes, thank you, Madam Chair. I'm going to turn this back over to Ms. Oaks, but we don't normally give you a presentation on student October count, but because this was an unusual year and many folks are asking about it and asking about the impacts, we thought that we should share with you what we learned. And so I'm going to turn this back over to Ms. Oaks to share that information.
Great, thank you. So I'm going to share my screen with you. So hopefully you can see the presentation before you.
Yes, we can.
Great, thank you. So this is preliminary data. Again, as I mentioned very quickly just now, we have the student October data that, you know, it's often referred to as a one-day count, but really it starts the day that students walk in the door and then it continues through November. So that counts the students that are enrolled and participating in their schools and districts on October 1st, which is typically the pupil enrollment count day, but that could vary based upon weekends and holidays. So we have the preliminary student count again in mid-December, but there continue to be some finalization and refinement. And so that will ultimately be released in January. And as the commissioner mentioned, that's normally when this information gets released, but because of the interest in what happened with student enrollment this year, we released some preliminary data. So This year, we did have a decrease in pupil enrollment. The last time we had that was in the fall of 1988. So that's very unusual. Typically, enrollment, as you know, increases slightly each year. This year, based upon that preliminary data, the estimated enrollment decrease was just under 30,000 students, which represents about 3.3% of all students. So that decrease wasn't across the board. The largest decreases were in the earlier grades. We'll go into a little bit more detail in the next slide. And it wasn't consistent across the state. So many districts did have a decline in enrollment, but about 40 had increases in enrollment. We also saw some trends of homeschooling students. So districts report the number of students who are homeschooled or reported as homeschooled, and that doubled to almost 16,000 students. And then the number of students who are registered in online schools increased by 44%, up just over 32,000 students. So here is a slide that shows how that enrollment differed among the grades. So as you can see, the preschool students had the largest decrease in the number of enrollments compared to last year. Kindergarten was also significant, elementary less so, and then actually in high school, we had a slight increase in the number of students enrolled in high school. That was a little bit in 9th grade, a little bit in 11th grade. 10th grade was a decrease, but a lot of those were in grades 12. So there was a slight increase there. And again, that gets you to your 3.3% decrease. We also collect information on the free lunch or reduced lunch eligibility status of students. So that decreased for the free lunch eligibility, which is also used for the at-risk funding factor in the formula. So that decreased about 1.7%. That's not as large of a decrease as the 3.3%. And that may seem reasonable given many of the students who are eligible in free lunch are through the SNAP program or the food stamp program. So that eligibility would remain constant, but potentially they are not as enrolled. A few of those students are not as enrolled. Reduced lunch eligible, as you can see, had a large decrease, 19.5%. That we don't think represents the economic status of those households across the state, but really a factor of just families not completing that free and reduced lunch form, because students become eligible for reduced lunch meals primarily through that application of that form. And many families were not filling out the form because USDA, the Department of Agriculture, allowed breakfast and lunch to be provided to all students for free this year because of the pandemic. And then also some students who may be in a remote learning environment and not at school to eat, it's just not front of mind for parents to fill out those forms. So that's what we think drove the decrease in those, not really the actual economic status of families across the state. We look at enrollment changes by race, and there is some variety based upon racial. So 5.8 American Indian or Alaska Native, that is a smaller subset, as you know. So there was some variation there. The biggest enrollment decreases in terms of the districts. Again, there's a disparity across the state. You can see these are the districts with the largest number of decreases, most of those being in the urban areas. And then finally, thought it was important to clarify that all of these numbers are discussing enrollment or membership. And in that case, every student is counted as one, as a whole student. There's also funded pupil count, and that is based upon counting students as either 1.0 if they're full-time, meaning that they're enrolled in 360 hours or more in that fall semester. Some students are counted for funding purposes as a 0.5 or part-time funding. And then some students, if they're enrolled in less than 90 hours in that fall semester, they may not be eligible for funding. So there is a slight difference in membership counts and funded pupil counts. Additionally, the funded pupil count incorporates an averaging provision. And this has been in the School Finance Act for a number of years, where districts are automatically, their funded pupil count is automatically calculated as either this year's funded pupil count or the average of this year and last year's funded pupil count. So a 2-year average or a 3-year average or 4-year average or 5-year average. So that provision, based upon a number of districts having a drop of enrollment, many more districts have that averaging provision, and that averaging provision sort of softens the decrease in the number of funded pupil counts when there is a decline in enrollment. So while we saw enrollment or membership drop by 3.3%, the funded pupil counts only decreased by about 5,000 students, or just over 0.5%. And so that is the number that really drives the funding impact based upon the December true up and then into the January true up. So that is the presentation that I had for you today, but I am more than willing to answer any questions that you have.
Thank you, Ms. Oakes. This is not a voting item, but I would be glad to go down the list and see if you have questions or concerns. Board Member Rankin.
I guess I would just be curious about the average of this, not the average, but the numbers of this year compared to the past years, but it doesn't look like it's going to be that much different, Ms. Oakes, because of all the different ways you can determine how many students are there.
Yes, and so in terms of the funded pupil count, that decrease was a smaller decrease than the enrollment figures. And so again, with everything, you know, the variety of the impact in any given district is going to be disparate from the neighbors.
Thank you for that report. It was very, very thorough.
Thank you. Board Member McClellan.
Nothing from me, Madam Chair. Thank you.
Board Member Esser.
Thank you, Madam Chair. Ms. Oakes, I had just one question for my own clarification. When parents apply for free or free and reduced lunch, is there a deadline that you either have those applications in by the end of the count or you're not part of that cohort?
Yes, so a parent can fill out that form any time of the year. And then based upon that, so this form not only informs the October count and that at-risk funding, but it also is obviously for lunch and meal eligibility. So a parent can fill that in any time during the year, and then that student would then immediately begin receiving free lunch or reduced price lunch meals based upon whenever that application is submitted. In terms of funding, that form does need to be in by October 1st or whichever day. So if it's October 2nd in any given year. So as of that enrollment count day, that's when the application has to be in by. There is a provision that allows a carry forward of last year's eligibility into the start of the year. That's based upon USDA regulations as well as our school finance regulations. And that's a 30-day school day. And basically, I think the provision, the rationale behind that provision is that if you were free lunch last year, you start this year free lunch, eating for free lunch, and that gives a little bit of time to get that form in. So that provision does apply both to the lunch and meal eligibility as well as the funding eligibility.
So this year it wouldn't help or wouldn't change funding at all if we encourage parents who really need free and reduced lunch to sign up now because they're getting those lunches anyway.
Right. So there is, if you do not fill out that form, you still have free meals at school for the rest of the school year. We do think that it is a benefit for those families to today fill out that form anyway. And that way that will presumably that next school year will return to regular lunch and breakfast where students either have free lunch or have the reduced lunch or paid lunch. And so if you have that form in today, again, that will carry over for the beginning of the year. And so then a student who is free lunch based upon the form submitted at this point in the year would start the year eating free lunch next year. And then that can also help with the funding of at-risk students for next year because it can carry over for the funding as well.
Great, that's very helpful. Thank you.
Board Member Durham, do you have any questions about student count?
Sorry, no, I don't about the count. I just appreciate the, as I remember when I read the briefing paper, it did show the adjustments and averages that take place. And so the effect went from, I think, what, about 4% fewer students to, help me with my memory, 0.5% or 1% reduction in terms of number of students funded. And that's due to the cushions that the legislature's built into the law over the years.
Yes, that's exactly right. It went from 3.3% from enrollment or membership down to 0.6% for funded pupil count. And again, that will slightly change once we have the final enrollment numbers in a few days here in January, and then the final January true up, but it's generally 0.3 and 0.6.
Yeah, I appreciate you producing that information because I was reading some press accounts that greatly exaggerated the impact on dollars available to school districts as a result of the small enrollment, which was due to the result of the pandemic. And I always like to correct the record that the amount of money that the differential is extraordinarily small, and there's not really, perhaps only a very few of the most heavily impacted districts should have any problem with managing those kinds of reductions. So, and Madam Chair, I'm going to have to call it a day, and I have another appointment. So I think this is the last agenda item, and so thank you.
Thank you. Board Member Escarzaga.
Thank you, Madam Chair. I don't think I have a question about the October count in the presentation. Thank you. But I do have just perhaps a comment that when I'm looking at these kind of enrollment changes, and particularly the demographic shifts that we just saw. So you have the drop of white students at 4.1, Black Latino students around 2.6. So back back in the day when I worked for Aurora, and we had dramatically shifting demographics. Every year we saw exactly this happening. When I first came on, it was maybe 35% white, 35% Latino. When I left, it was 10% white. But the point is it's going to kind of circle back to the data question we were talking about earlier in testing, that I did a presentation for our board to show every student could actually achieve exactly where they were the year before, have the exact same scores. But because of our demographic shifts, the data changed significantly. In some cases, you could see improvement by all groups, but because of the shift in proportion of students, that gain was totally wiped out. The point being is that if there is testing and if there is any data to look at, the layering that you're going to have to dig into to try to make any sense of it exponentially, this is just on top of the fact that you're not going to have a representative group probably to start with. It's just something to think about. I know your data people will, and I'll be looking at that, but this is, like I said, I've seen this at a district level, state level. It just totally wipes out a lot of what you could do. So anyway, thank you, Madam Chair.
Thank you. Board Member Sheffel, I understand you're on the phone. Did you hear the presentation? Board Member Sheffel?
Yeah, so Board Member Shuffle, if you can hear us, you might have to do *6 to unmute. But is she the last one, Madam Chair, or do you want to go to somebody else? Oh, there she is.
I knew she'd show up.
Oh, sorry. I didn't realize I had to unmute that way. Anyway, thanks for letting me join by phone. I really appreciate it. I heard the presentation and I don't have any further questions.
Thank you. Thank you, Ms. Oakes. So Board Member Shuffle, why don't you stay right there and tell us if you have anything to report on activity since we last met, which I think was last November. It was last year sometime. I can't remember.
Yes, well, the holidays were an adventure, but I did do a couple of things. I was able to attend virtually Liberty Common High School's scholars for classical education, 13 years of participation, just recently, last Sunday, I believe. That was really encouraging, and a lot of great young people spoke at that, so that was in my district and a great event. Also, on the Bill of Rights Day, I was able to speak on a radio program about the importance of the Bill of Rights, and then I've been working with CDE on the whole READ Act implementation piece with programs and supplemental intervention and core programs, just to ensure that the process is working and the rubrics that are being used are ending up letting great programs through and catching ones that still have some alignment to do. So that whole discussion's been going on. It's been a good process to try to, think through. So anyway, those are, I think, 3 focus points for me for the last month or so. Thank you.
Thank you, Board Member Sheffel. Drive safely, please.
Thank you. I'm listening carefully.
Listen, but keep both hands, please, on the wheel. Board
yes,
Member
I will.
Do you have a report, Board Member Rankin?
I'm sorry, I didn't hear my name. Yes, I also attended Liberty Commons Scholars Program last Sunday, and it was really cute, really cute. I'd love to attend that sometime in person. I also was asked to be a judge on the high school civics program in the state. There's teams that compete, and the winning team goes to Washington, D.C. I learned something every time. I've been on that panel the last 2 years, and the 2 people on my team are always lawyers, and they're really, really smart lawyers, so I learn a lot from that. One of my superintendents left the county, Moffett, Dave Ulrich, and I know you've heard me speak of him a lot because of the READ Act and what he has done at his school to improve the scores. And he now has left for another state, and Scott Pankow is now the superintendent of that district in Moffett County. And I've had a couple of conversations with Scott. He is going to continue on with that reading emphasis, which of course makes me happy. Leslie Nichols, I want to shine a spotlight on that superintendent from Gunnison Watershed. She used to be in Hinsdale. She really did an amazing job at sending out notices to the community and the parents during COVID, and really keeping them tuned into what was going on in a very uplifted way. And I think it's great when, in gloom and doom times, it's nice to see people being informed by superintendents that really care about what they do, and she does a great job. On another note, going in another direction, I have spoken to some of the presidents of the universities in my district that are teacher prep programs, and I don't even have to start what I discussed with them, but usually in the beginning it was READ Act, well, what is that? And it did open up a conversation. One of this presidents, Carrie Hauser of Colorado Mountain College, hooked me up with their Dean of Education, Elizabeth Qualman. I had a great discussion with her, and I'm sure we'll be doing some follow-up on that. And then a really positive thing came out of Colorado State University in Pueblo. One of the constituents in board member McClellan's district sent me a link to a dean there called, and her name is Vicki Paquette. And she talked about her background in education. She's a dean teaching teachers. She has a master's degree in reading, and I do too. And she has never been taught the science of teaching reading. So I immediately identified with her. But she had gone to some courses and sat next to people that really knew what the science of teaching reading was all about. She had an aha moment and has studied and is now going to be, I believe, an adjunct dean while she's working on her PhD, putting, quote unquote, the READ Act into effect, although it's a science of teaching reading. But that was a real eye-opener for me in Pueblo, and I wish her all the best of luck, and I hope to hook up with her. I just heard this a couple days ago. Numerous meetings and telephone calls with CDE and Commissioner Anthus. I can't thank your team enough. I know you probably hear all the time, she called again, and she has these same questions I've answered, and I really appreciate all of their hard work. It's very useful, and I really think it's going to make a difference. Just keep it up. And that's all I have to say, but thank you very much.
Thank you, Board Member Rankin. Board Member Esser?
Thank you, Madam Chair. I am working with a group in Arvada. I don't know how many of you know, but the secondary schools in Jefferson County are a hybrid model right now where kids go twice a week, where they're in person, and the other 2 days a week they're virtual. And then Friday, I haven't quite figured out what Friday really is, but there is about 20% at one particular middle school of the kids that got a grade of IE. That's a new grade for me, which means insufficient evidence to be able to grade them in a particular subject. So there's a group of us that have gotten together, mostly community leaders, one of the store owners, a church, a couple of nonprofits, and we will be offering a space for them, for these middle school kids, to do their work on their off days. So they'll be expected to come, be in person. They'll be overseen by some high school mentors, and the high school mentors, I got to interview them. They're amazing. They're adorable. I hope they're not watching this. And that way, we're just trying to see if you give them a place to go, if they have some supervision, if they know they're expected to work, will we see a difference? So that's what we're going to start right after Martin Luther King Day. And that's the only thing I have.
That is great. Thank you. Board Member McClellan.
Thank you, Madam Chair. I'm sure that this will resonate with other board members, but it's been quite an adjustment not being able to meet with constituents or stakeholders over a cup of coffee or a bite to eat, or be able to meet them at a school or any place in person. So doing those contacts by phone is something I will not miss having to do when this is over. I much prefer to be able to sit down and have a cup of coffee, and I miss that. So I also want to share what an absolute pleasure it was to have had the privilege to work with the Special Education Advisory Committee. I'm going to be giving that committee a liaison role back to Dr. Scheffel, I understand, and that'll be going forward, that'll be in her capable hands at some point here, from what I understand, but it's just been a pleasure to work with them. So I wanted to share that thanks. I've also appreciated the opportunity to be a part of the governor's working group for the back to school working group. The product is not done yet, but it's a work in progress. But I've appreciated being able to be a part of that, doing a lot of listening there. So, and that's it. Thank you.
Thank you. Tell us more. What's the working group going?
It's the COVID back to school working group. So looking at ways to help ensure that everyone's needs are met and that districts have what they need and the information that they need. So I don't think that the cake is fully baked just yet, but glad to be a part of it.
Got it. Thank you. Board Member Escarzica.
Okay. Well, thank you, Madam Chair. Well, so since November, of course, the election is what we're talking about. We spent, Carla and I, Dr. Esser and I have spent a great deal of time in orientation. And I want to, I was remiss yesterday in thanking Ms. Maramba and the entire department for taking the time out to walk us through, answer our questions. And it was a very thorough orientation. And especially for this first board meeting where you're expected to actually vote, you need to be brought up to speed, and they did a great job. So we spent nice time chunking that out. It was wonderful. And very much to Member McClellan's point, you know, I think the first time we met, we actually had a cup of coffee. That's how I met you. Not being able to do that's very difficult. So I've been spending a lot of time, as everybody, on the phone, parents, school staff. I've got a lot of neighbors that are educators, so that's helpful. I meet them as we're walking the dogs, but talking to board members and legislators. And the nice thing too about Zoom is, you know, I only have 3 districts. Some of you have like many more, but I can listen and be involved in every single board meeting, and I can really keep up. If you listen to those board meetings, they are very helpful in understanding what the district's prioritizing, what their needs are, what they're struggling with, and you know, just how they're navigating the pandemic. So that's been kind of interesting. Of course, in Denver, we have Dwight Jones, who is our interim superintendent at the moment. Many of you may know Dwight, as he was Commissioner of Education at one point. And sometimes we used to say at CASE, you'll find the perfect leader for the perfect time. And I think he is it. And so far, so good. I look forward to actually meeting with him. So I would close maybe on just saying this. I actually wrote it down. That I really have never been more impressed by the dedication and love of our educators that they have for their students. Just during this pandemic, the evidence of that, I have never seen it be more. So thank you.
Madam Chair, you're on mute. Sorry.
Unmute.
So my apologies, but I missed part of it because I got thrown off and I have no idea why. So I just started over again. Very briefly, I think I'd like to share one of the items that I've been involved in, and that is a group called Education System Resiliency and Innovation Initiative. And we are working on teachers, what their experience is, how to attract them, how to help make their jobs better, et cetera, et cetera. There will be a report probably in the next couple of weeks, which I will make sure is shared with you, but it's about teacher training and supports, teaching and learning, educator workforce, et cetera. It's been, it was begun by PEBC and I think the Keystone Group are both sponsoring it. It's very interesting, and hopefully it will give us some ideas on how to make some changes. Hopefully the pandemic will give us an opportunity to make some changes that we'll be able to do a better job than we've been able to do up till now. So if there are no other items, colleagues, I will suggest that we adjourn this meeting. Thank you for a productive January meeting. Again, welcome to our new board members, and we'll stay in adjournment until our next regular meeting scheduled for February 10th. Unless Ms. Mello calls us at an earlier time at the end of January, but I really don't anticipate that to happen. So I look forward to seeing everybody again in February. Thank you very much.
Thank you, Madam Chair. Great meeting. Thanks to
Madam
everybody.
Chair.
Thank you.
Thank you.
Thank you.